the ideal feeling you want to get to.
Okay, kids, here we are at the slavery exhibit. Now, as you can see, the slaves were kidnapped from their homes, chained together for weeks. They would cram them onto these ships in very appalling conditions.
Thousands of women and children are being smuggled across the border.
Sexual trafficking of children. As you can see right here, they were treated like animals. They worked all day long for no pay.
Sweatshops raided by police. Children forced into slave labor.
Some of the slave masters were very cruel. They whipped them and they beat them, as you can see in some of these pictures.
Brutal, even fatal.
So, before moving on, are there any questions?
Does this still happen today?
We return to this prophecy that at the end of history there will be slavery. The greatest slavery of all is not the slavery which is behind us, but the slavery which is ahead of us.
The organizing principle of any society is for war. The basic authority of a modern state over its people resides in its war powers. Today, it's oil. Tomorrow, water. It's what we like to call the God business. Guns, oil, and drugs. But there's a problem.
I don't give a shit.
Our way of life. It's over. It's unsustainable and in rapid decline. That's why we implement demand destruction. We continue to make money as the world burns. But for this to work, the people have to remain ignorant of the problem until it's too late. That's why we have triggers in place. 9/11, 7/7, WMDs. A population in a permanent state of fear does not ask questions. Our desire for war becomes its desire. A willing sacrifice. You see? Fear is justification. Fear is control. Fear is money.
Just a minute. That's a little too controversial, and I don't think we're going to be... Here comes that black. Watch yourself. He's kind of smart, you know.
Appalled at what I see happening in this country today. We are told that America is the land of laws, a nation built on laws. In point of fact, nothing could be further from the truth. America is run by people who are lawless. We have no law in America, and understand that. The law is whatever the powers that be in power happen to say it is today. Whatever they say it is, that's what the law is today. And it may change tomorrow. So what you need to understand is this is not a nation of laws, it's a nation of lawlessness. And somewhere along the line, we're going to be dealt with by that universal God force because of what we have allowed to happen in our country.
Iconic American hip-hop artist Ice-T was here in the studio. The self-styled godfather of gangster rap had come to talk about a new documentary he's made about the art of rapping, which will be running on tomorrow night's programme. But while he was here and news about the Denver shooting was coming in, I briefly took the opportunity to ask him about his own attitude towards guns. And I asked him why he's such a defender of the right to bear arms.
Well, I give up my gun when everybody else does.
And is that
doesn't that make sense?
Well,
doesn't that make sense? I mean, if you were to, if there were guns here, would you want to be the only person without one?
So do you carry guns routinely at home? I mean, you have a gun at home?
Yeah, it's legal in the United States. It's part of our Constitution. You know, the right to bear arms is because that's the last form of defense against tyranny. Not to hunt. It's to protect yourself from the police.
And do you see any link between that and these sorts of incidents?
No. Nah, not really. You know what I'm saying? If somebody wants to kill people, you know, they don't need a gun to do it.
Makes it easier though, doesn't it?
Not really. You can use you can strap explosives on your body. They do that all the time.
So when there's the inevitable backlash of the anti-gun lobby as a result of this incident, as it always is.
Well, that's not going to change anything in the United States.
Anything.
No. The United States is based on guns. You know, like KRS says, you'll never have justice on stolen land. So it's not going to change.
And then when you leave, with all the hassle, can you have that love? How much lead are you putting in my neighborhood? Lead affects my thinking capacity. Lead is only one thing on the planet more dangerous than lead, and that's manganese. Manganese will make you kill your mama. And let me tell y'all something. If you want to see the largest homicide rate in the world, it ain't in no black ghetto in America. It's a little town in Australia where them white folks' homicide rate is 200 times what their population is. And that town just happened to be located across the street from a manganese plant. Here you go, right here.
Sit back down, Dick. Don't lose that mic. Yeah.
That town is located across the street from a manganese plant. How much manganese are you spraying in my neighborhood at night while I'm asleep? How in the world can a 9-year-old child find a heroin man, but the FBI can't find it, and you gonna tell me that's a black thing? Y'all crazy? What is this about? And then black men, as you run off to war and kill folks, liberate folks, and then come home and a white cop or a white racist mentality then shot your mom in the back, and you got to call him. You don't call the United States government. You don't call that bad army. And black men, how can you let cops shoot your mama, your dad, and your daughter in the back and don't do nothing, but you notice they ain't never shot your car? They ain't never took a nightstick and knocked your headlights out. And black men, you should feel ashamed that you think more of your car than you do your mama, than you do your daddy, huh?
I don't think so. I don't think so at all. I don't think the Queen has much power at all. I think she's just like anything else. She's a figurehead, just like Obama. He doesn't have any power over nothing. Got nothing. He's got no power over nothing. This is a white man's country. This is a white man's world. The white man from Europe dominates the whole planet. White men goes into any country and kill everybody, take over anything they want. This is a white man's country. It's a white man's world. I'm not bragging about it. I'm just telling you the fact of the matter. White people out of Europe have dominated Europe and Europe has dominated the world. And so England has manipulated and exploited the races, the peoples of the world. The white man has been using exploitation, commerce to manipulate and exploit the whole human race. So I cannot believe that some young black guy who walks in and he's going to take over the old white man's establishment on the earth. Ain't going to happen. No. They brought him in for some reason to make him look like a schmuck one of these days soon. But he is not in control. The men who are behind him is Zbigniew Brzezinski. You want to find out what's going on with Obama? Do some research on Zbigniew Brzezinski. Studied in Moscow. Pure Moscow communism. That's Zbigniew Brzezinski, and he's the brains behind Obama. Obama's just a front man. They get rid of him like they did Kennedy. He's a very powerful man. John Kennedy, everybody loved him. Handsome, debonair, president of the United States, wealthy, and they shot this guy in public, and nobody went to jail. Nobody's ever going to jail. Why? Because the powers that be that run this country will kill you. You think for 1 minute you're going to get out of line and be important in this country, they'll whack you so thick. As a matter of fact, the California state has a I don't know if you know this or not, but the mafia have their own license plates in California. Did you know that? Yeah. The mafia is given their own license plates by the California state government. I know because I've sat with the mob and talked with them. And they have their own license plates. I had a time, I'll give you an example of what I'm talking about, how government operates directly with the underworld. And it's one and the same thing. We're talking money, we're talking power. But the governor, it would not look right if a governor goes out and has somebody killed. So they make a phone call and that's taken care of. And the government doesn't know nothing about it, but they get what they want. So in payment, the government makes a contract with the mob. We don't mess with your business, you don't mess with ours. You take care of things that we need to take care of, we take care of you. That's what's going on in California. The mob has their own license plates, and the mob has a business deals with the state of California to take care of all the dirty work for them. So as far as I'm concerned, and I've been told by FBI agents, I had an FBI agent call me in my office in Glendale and tell me, Jordan, we've been watching you for a long time.
Assistant to Rumsfeld. I can't call his name. Who? No, not Pearl. Wolfowitz.
Wolfowitz, yeah.
Wolfowitz.
Hold your point, Minister. We got to go to a top of the hour break. That's the kind of information, though, that I wanted you to give us.
Carolina High School were injured today when a chemistry experiment sparked an explosion.
That's good.
Hazmat crews are still on the scene. A nurse who worked for Michael Jackson took
There's so many people who don't know that.
Conrad Murray today. Sherilyn Lee
And they don't know it because the media is bought and paid for. This is a hell of a betrayal of the American people when you will not tell them the truth because you're afraid that if you tell the truth, your bosses will take your job from you. That's a hell of a thing. You don't have a democracy when you don't have a free press. You're all slaves, and you love it. So you deserve what you get, the erosion of your democracy. You'll soon be the laughing stock of the world.
That works out to less than 50 cents a
It's a damn shame. That's why the children are occupying space in New York, in Boston, in Washington, in Chicago, in San Francisco, and other cities. Why? Because they're not looking to you as a source of information for them. Look how long it took you all to talk about what was going on in New York. It took you 2 weeks because the same people that control the banks control the media. You all know it, but you're afraid to say it. But God put it on Farrakhan to say it for you. And maybe one day you'll get some courage to stand up and give America free media, a real free fourth estate. But right now, you ain't even worth the time of day.
Local news headlines, traffic and weather up next on WBON.
I'm glad. Hell, I'm not hiding nothing. You need somebody to tell the truth.
That's right.
You need somebody that's not afraid to die for the truth, that you could be made free. Because you're not free. And you don't really know what it means to really be a free white person, a free black person, a free Mexican, a free Arab. If you're afraid to tell the truth, what future does your children have in a society where truth is brushed to the curb? I thank God for the young man that invented this wonderful technology.
Steve Jobs, yeah.
Steve Jobs. That's the man that's freeing the whole planet, where Zbigniew Brzezinski could say, yesterday it was easier to control 1 million people than to kill 1 million people. Then now he says it's easier to kill 1 million people than to control 1 million people, because
I think a lot of people have called me and asked me about sovereignty, and the way I understand it, I only kind of answer that question as it relates to the whole 30 to 60 million of us becoming a sovereign country within inside of America, unless some African government is going to cough up some land. You understand what I'm saying? You as an individual becoming sovereign and fighting these people downtown and filing some paperwork with the same people that got you in this situation in the first place is ridiculous. Ask the Native American how many times he filed some paperwork downtown with the treaties that he signed with these people. It ain't gonna happen. If they were already living on land that they owned, right? Then what happened? I thought they were already sovereign. I'm talking about the treaties that the Native Americans, all of the 200 tribes, the treaties that they signed with this government? Were they respected?
Of course not.
Okay, then what makes you think yours is going to be respected downtown?
Good morning. Peace to all the guys and goddesses. It's Wednesday, August 21st, 2013. You're listening to High Frequency Radio. Got a good show lined up for you today. Let me get a mic check real quick. Let me get a mic check. Five 12316. You're on High Frequency Radio. Five 561-1665. You're on High Frequency Radio.
Oh, can you hear me?
Yeah, I can hear you. Can you hear me?
Oh, okay, yes. Yeah, I had a question for you. I was thinking that if I looked on some things on the web on. Sorry about this. I'm just now getting started. I went through a foreclosure, and a fraudulent foreclosure, and looking through the paperwork that I've seen online about the judges not signing the orders, but the attorneys signing the orders. I was thinking, isn't the actual person that puts in the affidavit or is the true witness to, any of the transactions, the true judge, over anyone that's impersonating being a judge? Like, wouldn't I actually be the judge?
A couple of things. Okay. All right, that's a good question. Okay, first of all, I was doing a mic check. I was trying to see, can you hear me okay? Can you hear me fine?
Yes.
Okay, good. Okay, next, I'm going to answer your question. If whoever puts in an affidavit in a case, all right, subjects themselves to the possibility of being cross-examined on a witness stand. Doesn't necessarily mean they're a judge or anything like that. Affidavits, an unrebutted affidavit stands as truth in commerce. Now, if somebody has put in an affidavit, it is your responsibility if that affidavit is fraudulent or you feel like it, if you want to do what's called, I'll think of the word in a minute, you have to put in a counter affidavit. All right. You just can't say, oh, they put in an affidavit. They're the, you have to rebut everything that is put in by the opposing party. Now,
I'm sorry, you just went out.
Okay, can you hear me now?
Yes, I can hear you. I didn't hear what you said, and maybe a couple words that you didn't say, that you said.
Okay, what I was saying was, you just said that that they're the judge and I'm not understanding what you mean by that. Explain that to me. What you mean by when you say there's a judge.
Okay. Well, what it looked like on the paperwork is that, for instance, if the judge, the judge that's saying that he's the judge of the court doesn't actually sign the paperwork, but the attorney signs the paperwork as the judge, that the attorney is taking over the position of being the judge. And what I'm saying is if I've submitted an affidavit that's gone on with no response, then wouldn't I be the judge to say, well, to place an order of default?
No, that is a notary can issue a judgment on the facts of a case. All right, and the judge is the administrator's law to issue a judgment on the law of the case. Sometimes I've seen situations like that where attorneys have signed for judges, and that's usually, I guess that's in some sort of, if you notice it, I'm sure it's qualified. They're signing in a certain capacity or some type of power of attorney for that particular officer. So you need to look at it without looking at your paperwork. That's just hard for me to just say. But you have to have only a notary or someone who has the power to issue affidavits or to get somebody to swear under oath has the capacity to do that. And that's what we talk about, an administrative process. You do an administrative process, and you get a default judgment on these particular individuals, and that's all in accordance with Regulation Z, Truth in Lending, where you send correspondence to someone, you give them 10 days to respond, you allow them an opportunity to cure, you get your notary to issue a certificate of non-response, and you can read about certificates of notaries if you get an American jurisprudence out of the law library. And every county courthouse has a law library, and they're green books, and you go in there and pull down an Am Juris and read up on notaries. You will see there's a section in there that talks about notary certificates and whether or not if you want to controvert a notary certificate by parole evidence, which means oral, or something like that. It has to be clearly cogent, and really they can only do that with a jury trial. You have to have some sort of hearing or something like that, and where you can bring the notary in, and those notaries need to keep a good notarial record book because they can call the notary's record forward in court. But anytime affidavits are entered into court, there's always the possibility that you can have a hearing and pull that person on the witness stand to see whether or not you can impeach their testimony. But that doesn't necessarily constitute a judgment off the bat. No, just because you signed an affidavit, you entered it into the court and no one answered it. Now, you could move the court, I guess, if you filed an affidavit, you made it a part of the record, no one responded to it, and then I guess you could move the court for summary judgment. I don't see, and then you could probably name some sort of maxim of law or some type of equitable principle if you've invoked an equity court to support that contention. But that's just my opinion on that. I usually like to go the route of doing an administrative process, doing a bill in equity, and looking for summary judgment like that, because there's no material issues there's no material issue and controversy, and you should be able to get the court to just rule on it once you have your evidence lined up. But your evidence needs to be written. So go ahead.
Well, I filed an I filed a lawsuit in district court, and the judge dismissed it as mute, and then I found a counter. Well, I actually put on this paperwork that I was, if he was acting as my attorney, that he was fired. And then I filed another affidavit, and the bank had a lawyer respond to it, but he didn't respond in an affidavit. And so I sent it also to the circuit court, and they said that they weren't going to file it. And so that's where I'm standing right now. And so my thing is that they weren't going to file it. And so the bank sent me a letter saying, well, we're going to have our enterprise customer relations do whatever's appropriate. And they haven't done anything. And so my next step was, I actually looked on the tax records, and it from where I see on the tax records, it actually says that the sale was disqualified and that the only verified sale is my sale, is my deed. And that the deed that the person that's claiming to be the new owner has is disqualified.
Well, then you need to bring that into evidence. What you need to do is you need to do an administrative process against Excel or whoever this mortgage, I guess you're talking about, an alleged lender. And you need to bring that issue up. You need to bring that to their face that they need to that they have submitted fraudulent documents or unverified documents into the public record. And you would like them to respond to you and submit verified. Do a verified written request against them under the Fair Debt Collection Practices Act. That's what you do. Hit them with that. Bring them into court. I'm not sure why the judge, dismissed your case as moot. Did he give any explanation? Because sometimes they don't give explanations.
He said that that under color of law, I think I put something in about civil rights and contract rights, and he was saying under color of law that I would have to have a government agency come in for civil rights. This is before I really started listening to you and Truman and some of the other people talk about. I was just kind of going off of whatever I was taught, and
right.
College and high school, So now, I'm trying to figure out the simplest way to proceed, but it even looks like that I'm still the true owner of the property. And so what I was looking at is, that since they already acquiesced to the fact that, they haven't responded to the affidavit, that they've already admitted to their fraud, and that I should just file an eviction for whoever's trespassing on the property.
You can do that. The only way the only real defenses we have, and I'm about to discuss it.
You're going out. You're going out again. I just caught you when you said the only real defenses.
Real defenses that we have is set off, recoupment, and fraud. And I'm going to be talking about set off today as far as using bills of exchange, bonds, promissory notes, things of that nature. That's what I'm discussing today. And so listen in on the show today. But as far as I'd have to really see the paperwork, just to really make an accurate determination of exactly what went on. I'm listening to what you're saying, and some of the stuff is understandable. Some of them I'm a little bit confused about. But more so than not, what you're dealing with when you're dealing with these mortgages, you're dealing with a trust situation, and that trustee doesn't have any liability. I've been studying a lot about these trusts lately. I can tell you this: there is very little that they are doing wrong. It is more so our ignorance that is getting us in trouble. The more and more I study this trust law, the more and more what they're doing is they're bamboozling us into voluntarily giving our property away. That's what it is. That's the basis, of everything. Everything they're really doing is essentially correct. It's just that. Well, I was
one of the robo-signers too. They one of mine. I was one of the people that they robo-signed with.
Okay. I mean, I had that too. I've had plenty of clients. I've had some of those major robo-signers like Green and a couple, and I called down and they put a gag order on the law firms. They can't even discuss the robo-signing now. That one, the chick, Green chick, I forgot her first name. She was real big. I had clients had that all in their particular documents. I've been doing this. Let me tell you something. I started doing the foreclosure defense about 4 years ago. I started when they was doing produce the note. Then we had the robo-signers. Then we had the bifurcation of the note and the security deed. Then we had, all these, they ain't really loaning no money, this vapor money theory. I mean, I've watched it go through a lot of different processes with the court. And a couple of times it should have started with the produce the note. That should have been it. But every time that come up with something or find some type of evidence that there's fraud, they find a way to circumvent it. And that is because one of the things that they're not going to allow to happen is they're not going to open a door where millions of people can walk through the door and get clear. They're just not going to do that. I just don't see them doing that, you know.
Yeah, but wouldn't that, because to me, since the warranty, the special warranty deed was conveyed through fraud and conveyed from the bank, wouldn't that be void anyway?
How was the warranty deed conveyed through fraud?
The special
Explain
warranty
to me the fraud.
deed.
Okay, well, how was it conveyed through fraud?
Because, well, you know, at this point, the way I look at it is that I don't necessarily, they've already acquiesced to the fraud.
Okay, do you got a certificate of non-response? Okay, well, do you have a certificate?
I was in the process of, that was going to be my next step.
Yeah, you want to get a certificate from a notary evidencing that they have, and where's your proof? You don't have any proof they respond.
Well, I filed it in the district court and also in the circuit court.
Fine. Okay, fine, but you still don't have any proof that you can put on the respond. That's what a certificate of.
Well, let me ask you this: couldn't I get a certified copy of the filing and then have that notarized?
A certified copy of the filing, and no, what you need to do, is you need to send it to them. Just because you filed something, first of all, doesn't make it a part of the record.
I sent it to them also, and I provided the court with a certificate of service.
Okay, you got a certificate of service. Okay, that's cool. I would have used an affidavit of mailing by a notary public because you want to involve a notary's job to be a witness. Let me tell you something. The Bible requires that you have two witnesses. You always need to have two witnesses. The post office can serve as a witness, which is that certified green receipt, and your notary can serve as a witness. Those are two witnesses. All right? You always have to have two witnesses when you go to court in anything that you do. Just keep that in mind. That is a principle. I don't care if you get invited onto Judge Judy and you got, whatever. You pay attention. Those people don't know what they're doing. They go into court. It would be helpful if you had two witnesses to come with you to court. You have two witnesses to come to you to court whatever they're doing. A notary's job is to be a witness. What they do, they witness transactions. They witness things. So another job they do is they protest. They do certificates of non-response. They are not a party to the proceeding. All they are is just a third-party witness to what is going on. So what you do is when you mail any correspondence, you do everything in writing and through the mail. You mail something to someone, you mail them a letter saying, "Hey, look, this is the evidence I found. I believe this is fraud. I'm going to give you 10 days to respond to this. But if it's regulated by statute, it could be longer. Like if you're doing a validation of debt, or according to the Fair Debt Collection Practices Act, they get 20 days to respond. So you're going to give them 20 days to respond to your correspondence. If they don't respond within the 20 days, you have the notary send them a notice of default. The notary says, "Hey, look, 20 days ago we submitted information to you requesting that you verify particular information." You can find that in subsection B of 1692G also, where you are verified. And people need to understand there's a difference in verification and validation. They are not the same thing. If you ask somebody to verify
subsection V?
Subsection B, yes. When you read that, it says that when you send this off, that they have to provide verification. All right. Now, when you get in a Black's Law Dictionary and use a recent Black's Law Dictionary for this, use a recent one. And what you do is you let them know. They say, okay, on the Black's Law Dictionary 9th edition on page 1698. That's the page it's on. It gives the definition for verification, which is a formal declaration in the presence of an authorized officer, such as a notary public, or in some jurisdictions under oath, but not in the presence of such an officer, whereby one swears to the truth of the statements in the document. Traditionally, a verification is used as a conclusion for all pleadings that are required to be sworn. All right, and it's also another term for it is affidavit of verification. That's another name for verification, is affidavit of verification. So you want an affidavit from them. You can get examples of this affidavit if you get a document called Banker's Secret Manual. You can get it off the internet. In there, it has an affidavit that you send to the bank. I use it all the time. That's the one that I use. It comes out of the Banker's Secret Manual, whereas I send a affidavit to them where I want someone from their particular financial institution to swear under penalty of perjury that they indeed gave a loan. Because if you read your security deed or your promissory note, it says this is for a loan I have received. So if you have received this loan, what they're saying, that, yeah, you received a loan, okay, then sign this affidavit because you didn't get any loan. You never got any money from these people. They never gave you a dime. All right, this is where the fraud is coming in. So so I'm gonna send you a verification of debt request. I'm gonna ask you to provide sign this affidavit and send it back to me because the only way that claims have to be verified. All right, there has to be something verified behind it. If you have a claim, you have to verify it. They are filing unsubstantiated claims, and they're using procedural maneuvers to outwit us and steal our property. That's all they're doing. They're using procedure.
Yes, I understand, but that's actually something that I have some trepidation about is the notary, because I'm like, then aren't you you're submitting under their authority too, right? When it seems like to me, like if you just affirm it, that affidavit should be law until it's contested or rebutted.
Well, you need a witness that they got it. You need a witness. The notary is serving as a witness that you mailed something and that they didn't respond. That's all the notary is doing. The notary is not involved with the facts of the case, the content of the correspondence of your affidavit, whether it's true or not. All the notary is doing is serving as they did not respond. Now you have evidence that they respond.
You have them send it to the notary, or they send it to you?
They send it to the notary. They don't send anything to you. The notary is the bridge between the public and the private. Once you obtain the services of a notary, all the correspondence from these financial institutions are supposed to go to the notary, not to you. Everything from this point on goes to the notary. I tell them that in my correspondence. Don't mail anything else to me, because don't they do that to you? They tell you also that, when they hire an attorney, you can't mail nothing else to them. They say the attorney is serving in the same capacity as the notary. They get an attorney to serve as a witness to a administrative process. That's all. The attorney doesn't have firsthand knowledge about anything. All the attorney knows is that, hey, they came to hire me to do a procedure. I'm supposed to hit you with a 30-day notice according to the Fair Debt Collection Practices Act. If you don't answer that, now you're in default, and I can move forward and put a notice in the newspaper. Nobody answers that in 4 weeks. Then I can issue you a demand for the premises, of which you don't answer that. Now I can go in court and file a dispossessory or unlawful detainer and kick you out of the house. And that's all a procedure.
Can you serve them through email?
Email can serve as evidence in a court. It can. I wouldn't. You need to look into your state statute under the rules of evidence. But email in a lot of situations, yes, can be used as evidence, as pretty good evidence also. But yeah, email is electronic correspondence is, because of the age we live in, is viewed as valid evidence in court. I don't know the statutes off my head right now, but yeah, I know that's true.
Because I was looking at it, and it's like they have a postmaster and a server, and it's mail. So, and that's their domain. So, I was thinking that maybe that could be, my proof that they were served also.
It could be,
what?
But let me ask you something. If your house, this is your house, I guess we're talking about, right? Then you should spare no expense in trying to save your house. Use your email, notary.
I was looking at that as like another option.
Yeah, use an email, use a notary, use 2 witnesses, use whatever at your disposal, but at the same time, this is your house. I tell people all the time, spare no expense in the saving of your home. This is, you're trying to save your home, Like, I'm sure that you go read, what city are you in?
You said what? I'm in Florida.
Florida has, I'm sure they have an evidence code. Go into your statutes there and look at the rules of evidence. I'm sure they have a code, and then you need to read that, and it will probably enlighten you to a lot of different things. Just read the statutory code for evidence and see what's admissible and what is not admissible. And what you're going to know, what you're going to find out is the statutory codes just acknowledge common law principles. And that's why I told you to read the Bible, because out of the evidence, what you're going to see, if you have a keen eye, you're going to see the same thing in the Bible, in the Old Testament, under Leviticus. That's why I'm telling you about the witness thing. It's like, that comes out of the Old Testament. So, use evidence. And when you read the clerk's practice, they call it half-proof and full-proof. They got a thing, page, you can look at it, they talk about half-proof and full-proof, which people should go and investigate. I think today they call it like slight evidence and or full evidence. They've changed the terminology today. But you go and see that these principles have been around for a very long time as far as evidence is concerned. But,
what's interesting is I saw some videos by Rob Ryder, and he was saying that, what you do is you acknowledge your deed, and then you get a certified copy of your deed, and then you have a officer of the court notarize the deed, and then you get the certificate of authority from, the Secretary of State, and then you already have two witnesses. You have the Secretary of State and you have the notary.
Okay, that I know. Yeah, I've read Rob Ryder's stuff, and I have some deed acknowledgments, some very nice deed acknowledgments that I have done, and I'm sure a lot of other people out there have acknowledged deed, and that's not, and I'm sure a lot of people out there also will testify that didn't save their house, just acknowledging the deed. Rob Ryder has done a lot of very good research, and I admire his research that he's done, and it's right on point too. Right on point. As a matter of fact, I went in Georgia and did some research on deed acknowledgments and found some that were over 100 years old. These clerks, sometimes they try to act like they don't know what a deed acknowledgement is, but in Georgia, I actually found an acknowledgement of a deed form in a book. That's about, and people can go look this up on the internet. I found it on the internet. It's over 100 years old. So yes, this is something that is definitely a deed is signed, sealed, and delivered. And you have to acknowledge receipt of it. Most people don't do that. It's just signed by like you're talking about the warranty deed, and it's just signed by the grantee, and it's not signed by the the grantor. The grantee doesn't sign it. No signature on there.
Well, I have one other question, and it's kind of a separate question. But the first day of school's starting up now, and there's a lot of things that I think that go on in the school where they don't always abide by my kids' allergy needs and dietary needs and things like that. So I submitted them some paperwork saying that I have power of attorney over the kid's name, over the all caps name, and that I'm the executor of their all caps name, and that if any documents are submitted on their behalf, that I need to put my autograph on that and have full understanding of the document. Because
great. That's perfect. This was a perfect introduction to today's topic.
But I don't, but really, I don't kind of know what I'm doing. But I was just I got to do that.
It's a perfect introduction to today's topic.
Okay, great. Well, I'm going to call you back tomorrow. I'll free you up so you can give your lesson.
Okay. And just listen to what we're saying. We're going to be talking about that particular subject right there, your property, and claiming your property. Because what you're trying to do, you're trying to claim your property. So we're going to talk about that now.
And just one other question real quick. You know, and also looking at filing the security agreement and the UCC-1 and the UCC-3, you know, with the Secretary of States and all that, to me, I mean, I don't know, it seems like I'm still, like, submitting that to their control rather than that being in my own control by filing it with them.
A UCC-1 is just a UCC-1 is just a notice. That's all it is. You're giving the people notice. You're not doing anything. It's just a notice. I mean, I don't know how people think that they are turning some type of property over by filing a UCC-1. The purpose of the commercial...
But when you pay with their credit, you know, with their credit card or their, you know, money, their Federal Reserve notes.
It's just a notice. A gentleman always gives notice. I mean, you're paying for the filing fee. I mean, yeah, you have to pay. These people are working. You know, they're doing work. A workman is worthy of his hire. But the thing is it's just a notice. It's just a notice.
Okay, so in other words, but what I'm saying is, so when I use the credit card that was, you know, that I signed over, you know, to the IRS, that's not putting in any way the UCC under their jurisdiction.
Because you signed, okay, I'm not understanding. You said you signed a credit card. All right, and let me ask you this. This credit card that you use, did you get it with your Social Security number?
I think so. It's a bank account.
If you got it with their Social Security number, yes, it's their property because that Social Security number belongs to them, not you. That's why they can come in, seize your bank accounts, freeze your bank account, and do all those things, is because you are within the jurisdiction of the United States, not without the jurisdiction of the United States. You are not foreign. You are domestic in that particular situation. You fall under their jurisdiction. That would have more to do with your Social Security number than how. And then you do need to qualify. You need to qualify your signature because when you're talking about you're an executor and all these different things, you're really in the form of a trustee. And trustees can incur liability personally if they do not qualify their signature, saying that you need to look to the trust corpus instead of me personally if there's some sort of discrepancy that arises. That you're not going to be held personally liable.
Well, you know, I signed. You know, when you had on Yashawa. When you had him on, I guess yesterday or the day before,
right.
He had mentioned about you wanting to be the executor and not the trustee, right? Because you want to be the judge over your trust.
You do, and let me just say this. You know, I was reading. I got a book right now that I'm just going to direct people to read it. It's in my Dropbox. It is on the agency of trust for payments. A real good one that you definitely want to, let me pull this up. Trust primer, what is this, the trustee appointment power affidavit. Because I understand what they're saying, but I think some people are a little confused about trust. Let me see, where is this book? Yeah, there's a document it's called the Handbook on the Law of Trust.
Mm-hmm.
And it is in the Dropbox. It is an excellent book. And I'm going to tell you another good one that I think everybody should read. And let me see, distinctions between trust and other relations. There's a chapter in here that's called Distinctions. It's called the Handbook on the Law of Trust. And it is it's very good. They got a section in here that talks about distinctions between trust and other relations. And it talks about debtor. It talks about these mortgages. It talks about, you got to know what a collector is. Use some terminology you'll probably have to look up. And this what a partnership is, principal and agent, collection of negotiable paper. And it talks about this executor and this trustee type thing, and how you can be in a certain, you can be deemed in a certain capacity, if you do not, if the trust indenture is not worded a certain way properly, or if you do not qualify your signature in a certain way, you can fall in a certain capacity. I mean,
okay, so I put power of underneath. I put power of attorney, and on the side of my name, I put executor.
Okay, you sign an executor, but you're not really. I don't really think that tells how the liability that you're having. It's not really, you're not really saying whether you're personally liable or whether you're going to look to the trust, because you got to understand everything that's dealing in the public is trust law. Especially when you go on these courts, that name on that particular at the caption of that pleading is not you. That is constructive trust in equity. And trust law is always enforceable in equity. It's only enforceable in equity, solely in equity. All right, and which is the purpose of it doing an administrative process to demonstrate that you have clean hands and that you've done everything in good faith, because you can only approach equity with clean hands. So it is a trust situation that you're dealing with. And the subject of the trust, or the trust corpus, would be the charge or whatever it is that they're attempting to collect. And then there's going to be and you as an executor or a trustee, you have a certain fiduciary, even as an executor, you have a fiduciary obligation that you have to fulfill. And if you don't fulfill that, there are certain penalties that are commensurate with that. And, I could get into it a little deeper. I was just reading this last night too, because I've been doing a lot of study on trust information right now.
Well, I'll call you in a couple of days, because I'm trying to just figure it out. I don't know how that would just sending that notice would have me liable yet, but I'm going to be having a meeting with the school soon, and they're supposed to be submitting this paperwork to me. Anything that has their name on it, they're submitting for any kind of payment to anybody or for any reason. So now I'm going to have to really know how to sign it.
Yeah, if you look, I'm just sitting here looking at this thing right now. It on the handbook of the law of trust, under Section 2, you'll see it has a chapter devoted to the distinctions between a trust and an executor. It has it right here in the book. I mean, this book talks about all that stuff. So it talks about bank accounts, talks about the mortgages. I mean, it's a beast book. I mean, everything that we're talking about is pretty much in this particular book, and it's right there in my Dropbox. Here it is, executorship.
Okay. So I'm going to have to get on that. And also I was thinking of signing it sometime when I'm doing an affidavit, and as a living soul, of signing it my name and then mother as as an apostrophe mother.
Right.
What do you think about that?
Well, yeah, you can, but let me read this real quick. It says executorship. An executor differs from a trustee in that the rights of the legatee against the executor are legal, enforced through a probate or law court, while the Cestway K Trust's remedy is equitable, and a Cestway K Trust is a beneficiary to a trust. The executor's duties toward the property in his control are temporary duties of collection, conversion into money, and disbursement, whereas the trustee has more permanent functions of administration and management. Executors and trustees often bear great likeness to each other because of the title, which holds to definite property. Go to the next page. Hold on, I'm reading it on an electronic document. The right to the enjoyment of which is in another. Indeed, an executorship is sometimes called, in a non-technical sense, a trust. If A bequeaths $5,000 to B and appoints C his executor, C becomes, upon the death of A, the holder of legal title to. I'm not going to go all into that, but just read this and you'll see, and it gives you the distinctions, because there's a lot of similarities between an executor and a trustee, but there are differences. People need to learn those fundamental differences and their duties and their responsibilities and their relationships toward certain property, which is the subject of a trust. So, I mean, the most important thing he just said is executorship is legal, and that's usually adjudicated in probate or law. And whereas trust, like as I said earlier, trust law is totally 100% enforceable in equity, in an equitable situation. So those distinctions need to be understood when, you approach these different things. Just put out there, well, I'm the executor of the estate, and you don't even know what that is or know what type of property you're dealing with or anything like that. People are just throwing things out there. People really need to get into a study of trust law. You need to start reading trust law. Everything you need to do, you need to just start leaving everything else alone, start reading trust. Because everything, if you look at all these properties y'all fighting in foreclosure, every single one of them have been placed in a trust. Every single one of them in a trust. So you got to understand trust law, because a lot of these things we're saying, when I go and study trust law, and then I look at what these attorneys are doing, I'm like, wow, they really are doing everything the right way. They're not doing it wrong. They're doing it, they kind of, it's you're doing fraud, or the bank can't own property, or but then you go and read what it talks about in trust law, and you say, dang, these people are just following a formula that's already been laid down thousands of years ago.
But is that according to the Constitution or to common law?
The Constitution is a limitation on governmental powers, okay? So constitutionally, there's only a constitutional encroachment if they are stepping on your private rights. And on the private side, you got a right to contract unlimited. And that's what you did, because you signed the contract and didn't read it. So how is that encroaching on your constitutional rights? Private law constitutes contract law, property law, and tort law, and status law. And public law constitutes constitutional law, administrative law, public international law, and criminal law. And you need to know these distinctions. And, they say, well, you're stepping on my constitutional rights. No, they're not. No, they're not. That's why they're putting it in a trust. They're not. They're not violating your constitutional rights. Most of you aren't falling within constitutional protections because you don't have the status for constitutional protections, because you own the public. You're a U.S. citizen. So you don't have any constitutional protections. Somebody sent me an audio. It's real good yesterday, and I had a chance to listen to it. This dude's name is Rodney Taylor, I think his name is. And they Skyped it over to me, and I listened to it. And the gentleman is real knowledgeable. He's a student of Winston Shrout. And he talks about the property being seized and the fraud that goes on at the closing table, and how it's called, really what it's called fraud in the factum is what it is. Fraud in the factum is when you are made to sign, you're asked to sign documents, and you haven't been given full disclosure that you are actually signing a negotiable instrument. And which he reveals in a very, very eloquent way that this promissory note is a contract. It's actually a check. It's signing a check. And I like how he broke it down. Very, very good audio. I'm going to put it in the Dropbox so people can listen to it. But, that's essentially what's going on. It's fraud in the beginning, fraud at the end. And what's happening, you're being defrauded in the beginning because you're not given full disclosure of exactly what you're getting yourself into. However, some of the fault does lie on your head because you're not reading the contract. You're not. It tells you very clearly in there some things. You are warranting that this property has been seized fully, and that means that you own it outright, and now you're giving it over to them. And when you give property over into trust, you don't have to have consideration, because everybody's saying, well, you need offer, acceptance, and consideration. You don't if it's been gifted. You don't have to have consideration. So, these are little nuances of the law that people aren't studying or aren't apprising themselves of. And they're going out making allegations, against these people. And the judge is sitting there on the bench taking silent judicial notice of the fact that you are 100% ignorant of the law. You know what I'm saying? We're just ignorant of this. Even me, I'm still learning stuff. I don't know everything. I'm learning a lot of stuff too, but I study every day. It's just like, if you look at a karate movie, you look at these dudes, they studying styles and everything, but they practice every day. You have to practice every day to become a master. You know what I'm saying? So you got to be good at this thing. So we just jumping into this. These attorneys been attorneys 25 and 30 years. We've been studying this stuff 3-4 years. These guys got a big jump on us. Trust me. They know a lot of stuff. So, you know what I'm saying? They've been doing this for a long time, and they know, you know, we sitting here, you know, we just learned this. Like me, I can only say I've been really studying about 7 years. You know, my first attorney that, you know, I had as a public defender when I first started this, he'd been attorney 25 years, and that was 7 years ago. So, you know, anyway, let me get into the show because I know people are waiting.
Thank you.
No problem. All right, you're welcome. Y'all must want me to, John want me to talk about the UCC stuff? Y'all just want to talk on the phone today? I tell you what, I'm going to do this. I'm going to take a couple of calls, and I'm going to devote the last, 45 minutes, and I'm going to go into this thing. I'm going to take a couple of calls real quick. Let me see who's been on the line. 301-6825, you're on High Frequency Radio.
Peace, Yusuf.
Peace, what's going on?
This is Brady Bad.
Hey, what's going on, Brad?
That was a real good discussion. One of the things that I'll share with the audience that worked for me is using UCC 9-210 as a it's a request for a statement of accounts and a statement of the collateral. I'm aware of that. When they don't respond to that, when the trustees don't respond to that, that's a statutory trust. They have a duty to respond to that.
Right.
And when they don't, that's breach of trust. And it's coming from the beneficiary.
Now, that's true. Now let me give everybody a jewel. I'm about to drop one out of pocket. I'm about to drop it out of my pocket. Okay. When I was in, when I first started studying it, I was in jail, and I was in the jailhouse law library, and I'd been told to study these American jurisprudence. I was into these American jurisprudence. Hey, Barad, are you still there?
Yeah, I'm still here.
Sorry about that. I got disconnected. What was the last thing you heard me say?
I don't remember.
I was saying what?
I don't remember what you said. I brought up the 9-210 and the.
Okay, I got disconnected then. Okay, I was saying that I'm going to drop a jewel for everyone out there, and that is on the when you said about the breach of trust. And that was absolutely 100% on point. There is a form book. You need to go to the law library and look up American jurisprudence. When you study American jurisprudence, you will see that, like, for instance, if you go into notaries, you'll see that there's a number at the end of every sentence in American jurisprudence. And when you go down to the bottom of the book, it will have a citation of authority. And then after that citation of authority, it'll tell you what form to fill out. There is a form for breach of trust. Everyone should go to the law library and get an American jurisprudence and look under the forms part of the book. All the forms you need are already there in an American jurisprudence for any action you want in court. Go look it up.
That's a jewel. That's a jewel. Yes, it is.
It's an American jurisprudence, all right? Go look that up.
And let me say this about the 9-210. In 9-625, it says that when a creditor doesn't respond in the right amount of time, a judge can restrain collections activities upon the acceptable conditions. So it's kind of open-ended, but if you enforce that with your words when you get to court, it can cause a lot of problems.
Right. I mean, but you need evidence. It's not evidence, you know, if they don't respond within a certain amount of time. Now, if you're doing filings, the record, I guess, will reflect. The filings will reflect if something hasn't been responded to in a certain amount of time. But if you just send a letter to a verification of debt request to a lender, you need to have evidence, and that's why you send it certified mail. And they are supposed to be sending stuff certified mail. That's another thing. If you pay attention to them, and these people, they are a trip. I mean, they'll send something to you, act like it's been sent certified mail. It's not even sent certified mail. They just put a certified mail number on it and put it in the mail and mail it to you. I mean, they just really think we are stupid. And that is why I'm doing a show like this, because I want them, because I know they're listening, I want them to get a clear understanding that we are coming for you. We may not know everything, but we're going to figure this thing out. This bullshit that they're doing is over. It has to come to an end. It has to come to an end. We got to put a stop to this. It's ridiculous. It's ridiculous what they're doing. It's ridiculous. This is utterly ridiculous. It's ridiculous. The things that they do, the things that I see that they do. It really, the person who taught this to me said, when I figure this out, it's going to be funny. And he was not lying. He was not lying. He was not lying, because this shit is funny. You be laughing some of the stuff they do. And, and when you're in an ignorant state, you be looking at this paperwork, and it look like something real official. Like, oh, my God, they just sent me this paperwork. They served this paperwork on me. But then when you learn what's going on, you're looking at them, I cannot believe they sent me this guy. Man. Your whole paradigm shifts about what you're looking at. It's a whole different perspective on this paperwork that they're giving you. You can see that this is ridiculous. They are throwing shit against the wall, hoping something stick. Or they're trying to avoid some type of liability or something like that. I was reading I got to read this. This was out of Express Trust under the common law. I put this in all of my verification of debt requests now. I put it at the beginning. And I'm going to read this to y'all. It's very, very good. It says, the person who creates the trust may mold it into whatever form he pleases. Carry on trust. And then here's a statement. This was a banker in the early 1900s. His name was Mr. J. Edward Simmons. He was the president of New York Chamber of Commerce and for 22 years president of the Fourth National Bank in New York. And he gave an address on October 5th, 1905 before the Maryland Bankers Association. Now check this out, y'all. It was on honesty is the best policy. Forcibly emphasize the basic principles involved herein, according to the New York Daily Tribune of October 7, 1905. And here's what he said. He laid his finger on the real trouble when he declared that the most demoralizing force in business today is the divestiture of personal honor and personal responsibility allowed in modern methods. The extension of the principle of incorporation has enabled leaders in business to set up two standards of morality to maintain a Jekyll and Hyde duality, and to do as members of an impersonal and non-moral corporate body acts which they would shrink from as individuals. What is wanted if we are to preserve rigid standards of honesty in business dealings is adherence to the old notion of personal responsibility and personal integrity. And here's what he said. He went on to say, he said, men, said Mr. Simmons, who pose as the salt of the earth and who condemn without reserve those who steal $50 or forge a check for $100 or accept a bribe will themselves make millions by lying, by fraud, and by bribery. In private life, they are stainless, but in the interest of corporations, of the trust, of the gas company, of the railroad company, of the insurance company, they will have recourse to every villainy damned in the Decalogue. Now, what he was saying right here is what we are experiencing today. And I'm dealing with, like, a lender right now, Green Tree Servicing, and another company, and I'm going to talk about these real quick too, is that these people are using corporations to do their dirt. Now, you meet these people on the street, and they will act as if they are some type of upstanding citizen or something like that, but they're using these corporations to hide what they're doing, the dirt that they're doing. That's what they're, and like, for instance, I went on this particular company. The name of the company is, I'm going to give y'all, they real big on the West Coast right now, and they got a lot of complaints. Quality Loan Service Corporation. Now, when you look up Quality Loan Service Corporation, what you're going to find is that they're owned by a law firm. And that's what a lot of people that I found out also, that a lot of times what you'll do is you'll do an administrative process against one of these mortgage companies, and then the next time, the next thing you'll notice, you'll be receiving, well, we transferred this loan over to this company, and then now they're trying to foreclose on you. Well, if you go and do some research, a lot of times what you're going to find is that the same law firm owns both of the corporations. All they did was go and form a new corporation to go and try to foreclose on people because they probably violated some Fair Debt Collection Practices Act or something like that. So they just form a new corporation to do some more dirt behind. You got to find out who is the owners behind these corporations. And then a lot of times what they'll do is when you go to the Secretary of State, they won't even list who the officers of the corporation are. So that in itself, to me, is a signal when you don't even want to put your name on your corporation. That right there lets me know that you plan on doing some dirt, especially if you're in the business of foreclosing on homes. You hiding behind a corporate veil to hide your dirt. And this is what this man was talking about 100 years ago, that they're doing the same thing. That document, Express Trust Under the Common Law, is an excellent read. It is required reading. But many people may not understand it if they don't have an understanding of corporations and trust and what a Massachusetts trust is, or a pure trust or a business trust organization. If they don't understand what those things are and what private and public and private, they need to have a good understanding on that. It may be a little confusing. But if you got a good grasp of that, that's an excellent read. Express Trust Under the Common Law. Excellent, about 45 pages. It's going to enlighten you to a whole bunch of different things. It's been in the Dropbox forever. I'm sorry?
Is that the Carlton Weiss document?
That's not the Carlton Weiss document, no. That is a good document, too. But that's not the Carlton Weiss document. It is an old document. It was written, a commission was sent out to, what they were doing is they were trying to label Express Trust Under the Common Law voluntary associations. And what they did was they had an administrative hearing where there was a debate on this, and basically they served all this evidence of how, Express Trust don't in no way resemble a voluntary association. And this was done for taxable purposes and also for regulation. Because anything that's what they call pure trust. And people need to think about this. They hear this word trust, but they don't really think about the word. Trust means exactly what it means. It's involving trust. If your trust has to be regulated, it's not really trust. Do you understand what I'm saying?
Yep.
It means you're dealing with dishonorable individuals. But when you're dealing with a group of people who are all honorable, stand-up individuals, you don't need to be regulated. And that's privacy. That's private. That's maintaining your privacy. So then, and it's beautiful. The arguments that were presented in there were beautiful. We talk about constitutional encroachments. All these different things are discussed in there. And it is a very, very powerful read for people to understand so they can get an understanding of the difference between statutory trust and common law trust and the effectiveness of operating a business organization under a trust as opposed to operating it as a corporation that's been registered with the state. Let me take some more calls. Leave your mic open, all right?
Okay.
Okay. True Freeman, you're on the air.
Hello.
Hey, what's happening? You're on the air.
Hey, what's going on? Are you going in today, huh? Yeah,
I guess.
I just wanted to make a couple comments on a few things. Let me get back in here to a couple notes I wrote down. I was just outside. In regards to, when you was talking about yesterday, when you was talking about, I think it was yesterday, you was talking about how, us reporting these crimes to the very people doing it, we ain't getting nowhere. We got to go outside, outside these agencies that's basically committing this shit up on us, right? You know what I'm talking about? Okay.
Right,
now,
right.
I was doing a little research. I already knew that. Remember, the shit with the water situation and all that. I've done a video. It's already up saying, I'm called the FBI, the Internal Investigations Bureau, the sheriff in the county, and who the hell else was it? I forgot who else it was. I was going to notify whatever. But I just happened to even stumble up on the FBI's website. That's why I asked you about that color of law. Have you ever heard of the color of law statute? And basically, FBI is one of the agencies that we supposed to be reporting this shit to. And I tried to do that a while back in my dog case. And, basically the lady was telling me that, because I was trying to report the judges and everything. But they basically, refused to do anything, said that was not their duty or something, something like that. I actually even got the call up on YouTube. It might have even been last year. But I just let me read something to give somebody. This is right off the FBI's website to give them an idea as to probably one way we can basically report this stuff as to what's going on. And I urge everybody to look up the color of law statute. I hadn't even really heard of it until I came across this. I know about color of law, but as far as, their statute, them having a specific statute, I had, actually found it. But this is right on the FBI's website, and it's called Color of Law Abuse. It says U.S. law enforcement officers and other officials like judges, prosecutors, and security guards have been given tremendous power by local, state, and federal government agencies. Authority they must have to enforce the law and ensure justice in our country. These powers include the authority to detain and arrest suspects, to search and seize property, to bring criminal charges, to make rulings in court, and to use deadly force in certain situations. Preventing abuse of this authority, however, is equally necessary to the health of our nation's democracy. I don't agree with the democracy situation, but anyway, that's why it's a federal crime for anyone acting under color of law willfully to deprive or conspire to deprive a person of a right protected by the Constitution or U.S. law. Color of law simply means that the person is using authority given to him or her by a local, state, or federal government agency. The FBI is the lead agency for investigating color of law abuse, which includes acts carried out by government officials operating both within and beyond the limits of their lawful authority. Off-duty conduct may be covered if the perpetrator asserted his or her official status in some way. During 2012, 42% of the FBI's total civil rights caseloads involved color of law issues. there were 380 color of law cases open during this year. Most of these cases involve crimes that fell into five broad areas: excessive force, sexual assault, false arrest and fabrication of evidence. Now that's a big one. Deprivation of property and failure to keep from harm. Excessive force. In making arrests, maintaining order, and defending life, law enforcement officers are allowed to use whatever force is reasonably necessary. The breadth and scope of the use of force is vast, from just the physical presence of an officer to the use of deadly force. Violations of federal law occur when it can be shown that the force used was willful, unreasonable, or excessive. Then it says something about sexual assault. Then the false arrest and fabrication of evidence. The Fourth Amendment of the U.S. Constitution guarantees the right against unreasonable searches and seizures. A law enforcement official using authority provided under the color of law is allowed to stop individuals and, under certain circumstances, to search them and retain their property. It is the abuse of that discretionary power, such as an unlawful detention or illegal confiscation of property. That's a violation of a person's civil rights may occur. I don't really agree with that civil rights situation like you was talking about on the other day. But fabricating evidence against or falsely arresting an individual also violates the color of law statute, taking away the person's rights of due process and unreasonable seizure. In the case of deprivation of property, the color of law statute would be violated by unlawfully obtaining or maintaining a person's property which oversteps or misapplies the official authority. Now, they're doing this every day in all situations. The 14th Amendment secures the right to due process. The 8th Amendment prohibits the use of cruel and unusual punishment during an arrest or detention. These rights can be violated by the use or force amounting to punishment, summary judgment. The person accused of a crime must be allowed the opportunity to have a trial and should not be subjected to punishment without having been afforded the opportunity of the legal process. Failure to keep from harm. The public counsel and its law enforcement officials to protect local communities. It is shown that an official willfully failed to keep an individual from harm. The official could be in violation of the color of law statute. Now, the main part about me reading that is I've just done a video on this, too. I'll post it in the link. It just uploaded. But it says filing a complaint. So we keep filing these complaints with these retarded-ass agencies. That's what I'm going to call them. And when right here on the FBI website, it tells us, it tells us how to file a color of law complaint, okay? And it says, you file a color of law complaint, contact your local FBI office by telephone, in writing, or in person. The following information should be provided. All identifying information for the victim. So if you were a victim, you need to identify yourself and put all the information that would identify you. As much identifying information as possible for the subjects, including position, rank, and agency employee. So all the information that you have against, the perpetrator, which would be the public official. The date and time of the incident, the location of the incident, the names, addresses, and telephone numbers of any witnesses. That would be any public officials that were witnesses or any private persons that witnessed the incident. A complete chronology of events, which is basically a chronological case summary, which is basically everything that happened in exact order as they happened. And any report numbers and changes with respect to the incident report, cause number, etc. It says you may also contact the United States Attorney's Office in your district and send a written complaint to the Attorney General, Assistant Attorney General, Civil Rights Division in Washington, D.C. And it says FBI investigations vary in length. Once our investigation is complete, we forward the findings to the U.S. Attorney's Office within the local jurisdiction and to the U.S. Department of Justice in Washington, D.C., which decides whether or not to proceed towards prosecution and handle any prosecutions that follow. Civil applications. Title 42 U.S.C. Section 14141 makes it unlawful for state and local enforcement agencies to allow officers to engage in a pattern of practice of conduct that deprives persons of rights protected by the Constitution or U.S. law. This law, commonly referred to as the Police Misconduct Statute. Look that up too. I'll have these in the Dropbox shortly. Gives the Department of Justice authority to seek civil remedies in cases where law enforcement agencies have policies or practices that foster a pattern of misconduct by employees. This action is directed against an agency, not against individual officers. The types of issues which may initiate a pattern and practice investigation include lack of supervision, monitoring of officers' actions, which they never supervise them or monitor their actions, lack of justification or reporting by officers on incidents involving the use of force, lack of or improper training of officers, and citizens' complaint processes that threat complainants as adversaries. Under Title 42 U.S.C. Section 1997, the Department of Justice has the ability to initiate civil actions against mental hospitals, retardation facilities, jails, prisons, nursing homes, and juvenile detention facilities where there are allegations of systematic derivations of the constitutional rights of institutionalized persons. So what my point about reading that is I don't know, I haven't heard of anybody filing color of a law abuse claims against these public officials, because that's exactly what they're doing, and what we need to be doing is doing that through the FBI.
Yeah, they have statutes for that. They have 18 U.S.C. 241 and 242. 18 U.S.C. 241 and 18 U.S.C. 242. Those are the color of law statutory codes that people can do Title 42 actions against particular individuals. But the thing is this, in reading all of that, people have to understand what the jurisdiction is so important for people to understand. I got into a discussion with a sheriff 2 days ago, and I was asking him a question. I asked him, he was a brother, and I pulled him over. I said, can I speak to you for a second? He said, sure. And I said, what is the difference between the sheriff and the police?
I don't.
And then he gave me the generic answer, well, we're all law enforcement. Well, yes, I understand that, but you have a certain jurisdiction that you operate under. You're all law enforcement, but there's a jurisdiction. He said, yes. He said, well, we can come over and take over the police department. And what people understand is, if you notice, you don't see police in courtrooms. You see the sheriff there.
That's fine.
Hello? Hold on, let me mute some people. Okay, you don't see police in courtrooms. You don't see them in jails, because those are constitutional. When you restrain somebody's freedom, that's a possible constitutional violation. When you kick somebody out of their house, that's a possible constitutional violation. When you come to court, there could be possible constitutional violations. So the constitutional authority, the law of the land, is going to be present. You don't see police officers in those particular situations, because police are really, in my opinion, glorified security guards. That's what they are, with the power to put a deadly force on you. But they are security guards to the municipality. So in that capacity, yes, they are law enforcement, as he tried to say, but they have a certain jurisdiction that they operate in. Now, but everything that you just said applies to U.S. citizens. All right? They don't have, this is why I say read this express trust under the common law, because there's a section in there that says that every person has a sui juris right to arrange their affairs the way they want to. And that is, you can be as an individual, as a corporation, as an association, as a partnership, as a trust. If you notice, each of these municipalities, they are either unincorporated or corporated associations, partnerships. Go look into them and see how your counties have incorporated themselves.
Oh, yeah, you're right about that.
And the only way the only way that you could have any type of relationship with them is that you have to be viewed as doing business with them because they're corporations. So you would have had to have contracted with them in some shape, form, or fashion.
Right.
So what you're reading about is applicable to U.S. citizens when the Justice Department comes in, or the FBI, or something like that. But that doesn't apply to private citizens. Private people, the Constitution is the restraint on them. So a lot of things, when you see color of law violations, that's really talking about like private people too. You know, it's like when these people come in under color of law, acting like, okay, well, I'm the real police, when you know you ain't you's a damn police officer. You're supposed to be protecting this store over here. You ain't supposed to be over here in my private business, coming over here acting like, okay, we the police, and, you know, you got to do what we say because we the police. And I have a status of a private individual. You operating under color of law. Color of law means it looks like law. It smells like law, but it's not real law. You're making it everything look like it's official, but it's not official what you're doing.
And color of law also basically means taking what they're perceiving to be law and basically overstepping it, basically creating their own damn rules, which is what they're doing.
They are, but a lot of times they do. But a lot of times what they do is they either coerce us or trick us into contracting with them. They do it. Let me tell you, the government, and somebody said this once, and I have to agree with them. And people don't get mad at me for saying this, but I'm going to explain it. The government does everything right. They use trickery, they use deceit, they use fraud. They may use these things. However, when you look at the rules of the game, like even with fraud is permissible if it's acquiesced to under the UCC. It'll tell you that. Fraud is permissible. You can use fraud to get somebody in a contract. That's in the UCC. All right? These things, that's what I'm saying. We're playing a game. That's why I call the show Rules to the Game. You have to know the rules to the game. They follow the rules to the game, even when they're using fraud, threat, duress, and coercion, and all these different things. There is a certain rule that they are abiding by to implement that. Because their superiors are telling them it's okay for you to do this. And the reason that they're telling them this is because they know the rules to the game, because they're trying to evoke something. It's really precedent on what type of response they get out of us. It's what kind of response you're going to get, So we give the wrong response, then they're okay with what they just did. That's why it is important. That's why they tell everybody it is important to know your rights and to stand on your rights. And this is what the Bible talks about, too, when it talks about fear. Fear is adultery with God. It's like you sit here, people got a really, I did a whole show devoted to fear. Fear is an acronym, false evidence appearing as real. This thing, fear, you got to get a hold of it, because this is why it talks about in the Bible. And I think it's in Revelations. Let me see. It's in Revelations chapter 20. I think Revelations 20, where it talks about the fearful will be cast into the lake of fire. Also, this fear thing, we got to get over this. So they using rules that they know that they're committed to do. It's kind of like he had in Job when, Satan went to God and said, hey, Job is, he's only faithful to you because you put a hedge around everything you do, you follow him. And then God gave him permission and said, hey, okay, well, you go down there and do what you need to do to break him. See if you can break him. Go down there and break him. And he had permission, so everything that this devil did to Job, he had permission to do. So he didn't violate anything because he had permission to do everything that he did. So it's the same way with these people. We don't know the complete rules to the game. So a lot of things that they're doing they're doing within the ambit of their delegated authority to do, and we don't think that they do. But that's only because we don't know fully what our rights are, and we don't know fully how to stand on our rights. There's a difference in knowing your rights and standing on your rights. And that's what we got to learn how to do.
Exactly. Yeah, but see, the point was, because see, I'm getting ready to do something. I didn't try to address them before, but I'm getting ready to file a color of law complaint. I'm going to see where it goes. Now, let's talk about this. What we was talking about in the chat, these rights and who has rights and who doesn't. Now, I cannot remember the recent Supreme Court decision, but I have it somewhere. I'll locate it and get that up. But it's like they even ruled that corporations have rights. Corporations do have rights. They don't have the rights that man has because man rights cannot be taken by another man. Corporation rights can be regulated and taken by the corporation. See what I'm saying? But they recently ruled that corporations do have rights. Now, what is a corporation that has rights? Now, we have. I'm looking at it a lot different. Now, we have private rights. But our corporation, i.e. our straw man, fictitious entity, legal entity, etc., has rights as well. You see what I'm saying? So it's almost like a catch-22, But we have private rights, but our corporation, our straw man, has rights as well. This
when you look at when you read this document, express trust under the common law, there is a section where they explain that. Where they explain how the amalgamation that occurs between a corporation and a natural person, and how the corporations are not included under the 14th. I mean, it says this. I don't particularly understand this. It's the immunities clause or something like that. That is not applicable toward the corporations, but a corporation is a person. That's what they do have rights and duties. I tell people this all the time. When you go read administrative law, it will say that the United States can create a right, and for you to understand that sentence in administrative law, when it says that, you have to understand that the United States, in that instance where it's talking about the United States, is talking about in their capacity as a corporation. They are a corporation, and they have rights, but they only have rights within a certain sphere. The superior man stays in his own domain. Corporations only deal with artificial things. Look around you. Everything that corporations make are artificial. None of it's the food, artificial. Everything is artificial. We are people of the natural world. We have to get back to nature. I can show people on a piece of paper how the word corporate equals 666. I can show, and I'm going to put that on what I'm going to do. When my blog talk is over, I'm going to post it on the blog talk, and y'all can get it, a piece of pencil and a piece of paper, and you can check everything that I'm going to give you for yourself. And I'm going to post it on my Facebook as well. But if y'all want this information, but when using these corporate entities, anything that has to do with anything artificial is adverse to your spirit. It's artificial. You got to get away from things, and that's why even the hair, y'all got to get away from that. Y'all wearing other women's hair from overseas, cutting off these babies' hair, and y'all put it in y'all head because Indian hair. You don't know how that's affecting your spirit. You got to get away from everything artificial, because the closer you get to nature, the closer you get to the Creator. The Creator, when you look around and you look at the trees and you look at the air, you look at the water, you look at the earth, you're looking at God. So if you want to get close to God, you got to get close to that. You get this fat on your body because your body you're not putting food in your body. You're putting artificial things in your body, and your body is rejecting it, and it's storing it on your body, and you're calling it fat. And then you're getting all these ailments in because you're not putting real food in your body. Because if you ate real food, you wouldn't get fat. You can eat as many vegetables as you want. Nobody's ever gotten fat eating nothing but fruit. You can't get fat just eating straight fruit.
No.
And vegetables. You know what I'm saying? It's impossible. The body won't allow it. So, you know what I'm saying? So it's evidence that you're not adhering to natural things. And anyway, let me take some more calls, man. I'm gonna keep you on the air. I'm gonna keep you on because I got to talk about these bonds, because people tuning in because they want me to talk about these bonds and everything. Let me take a few more calls, and I'm gonna have to get into what I wanted to talk about today. 202-4089. You're on High Frequency Radio. 202-4089. Hit your mute button. 706-9808. You're on High Frequency Radio.
706. Yes, sir. Trying to get some of this. What's going on, Yusuf?
Hey, what's going on? Dalo Siku. What's happening, bro? How you doing?
I'm good, man. I wanted to go back, touch on two things, and I'm going to let you get to your bond.
All right, go ahead.
One is, what people have to understand when they're talking about trust or even breach of trust, they have to be able to prove a trust. And the court system has elements that you have to be able to prove. There are 4 elements that go into trust. One is intent, the res, trustee, identify the beneficiary, and a valid trust purpose. 4 elements. That's a little bit more than 4, but it's the intent, the res, the trustee. Those elements have to be proven. So when somebody say that they're breaching the trust, they have to be able to pull it. Then people have to understand that trust isn't under the legal jurisdiction. It's under equity. And then people will tell you that the equity jurisdictions have been merged with the lawful, but they haven't been merged. They're simply still existence under one roof. Because judges and chanceries, 2 different things, but chanceries are the ones that are able to see equity in certain bills in court. So, not only do you have to be able to prove it if someone breached your trust, but you have to be able to enforce it. How you going to whoop that ass if he did breach your trust? Where's the trust?
Well, one of the things about trust, too, is you have to approach trust and equity. It's a right. It tells you that when you read the definition of a trust. It's a right solely enforceable in equity, and you can only approach equity with clean hands. The thing called the clean hands doctrine, and with good faith. Now, to demonstrate clean hands, and what I tell people all the time is that you need to have evidence of clean hands. And the only way that you can have evidence that you have clean hands is you have to have conducted an administrative process, because your documentation will demonstrate that you have clean hands. And if you read creditor, and you said a very good thing about a bill, and people should look up the word bill. It's called a bill in equity, but in a law dictionary, you're going to find it just under the word bill. All right, and you should study that. That's a legal term. You should study the word bill very closely, because once you complete an administrative process, you want to file a bill in equity. That's you're invoking an equity jurisdiction. It's clean hands. Your remedy is res judicata, and what res judicata means, this thing has already been adjudicated. It's evidence that the facts have already been adjudicated. That is the purpose of the notary. The notary is a judgment on the facts. Now, when there is no facts in issue, there's no need for a bench trial or a jury trial, and you can move for summary judgment or declaratory judgment. Ask the judge for a declaratory judgment of the rights of the parties. And then you can seek some sort of damages or some type of other, equitable relief. But, you want to do this, and this is the purpose of doing that. An example of what I'm talking about is in that document, creditors and their bonds. If you look in that document, there is a bill in equity in there. You should study it and understand what the exhibits A, B, and C that you see in that document are referencing your administrative process. The exhibit A is your first letter that you sent to this alleged creditor, whether it be a court. And when it talks about a creditor, it could be talking about a court, because the courts are corporations. When you see creditors in the bonds, this is ABC Corporation. That could be a courthouse. That could be a bank. That could be anybody, because they're all corporate entities. So Exhibit A is going to be your initial correspondence that you have submitted to this alleged creditor. Exhibit B is going to be your notice of default and opportunity to cure, and Exhibit C is going to be your certificate of non-response. Now you have clean hands. Now you can approach a court of equity and seek a remedy, because now here you go, Judge, and I've laid this all out. I have all my greeting cards back. I have my notarized certificates from the notary that can only be controverted by a jury trial, and so I have a judgment right here on the facts. Here is the court, Judge. Would you please review this administratively and then come back with a determination of what rights I'm to be afforded?
Yeah, now if you go, let me add to that. If you can go to these PDF books online, like Google Books. You can go to Gibson's, Section 930, and it tells you how to put a bill and establish a trust. And there's some other things, like, for example, the brother was just talking about corporations have entities. If people get a book, I like to give you a reference so you can read it for yourself. You need to have the hard copies, that whole nine, but there's a book by Roscoe Pound, Roscoe Pound. He wrote a book called The History and the System of the Common Law. And in there's a section called Scheme of Legal Rights at Common Law. There's a section called Persons. And in there it tells you, it's basically what you already know, but it gives you a little bit more about a juristic personality. It begins with the legal requirements for recognition of a group of associates as a legal person has been fulfilled. So when they talk about corporations, not only are they people, but they have personalities as well. So your name, when people are saying they want to get rid of their legal entity and tie themselves out, what you should look at is if you have legal rights, then there's something else that exists. Not just the human, but the substantive. And that's all in equity, because the substantial right is the real thing. That's the real you. People have been looking at legal rights and they ain't winning in court. They're looking at the courts like the courts are just whooping ass because they don't understand. Not only is it just racist, but they don't understand the legal implications or even how to apply the legal rights.
Well, that's what I'm saying. We're definitely ignorant about a lot of things. And, that's why I'm saying people need to reserve judgment on a lot of these attorneys and judges until they get a full, in-depth understanding of what's going on. And then 9 times out of 10, they put themselves in this own situation, especially with these mortgages, because they're signing documents and they're not reading them. They're not reading them at the closing table, and they don't even understand what they're signing. So, there is some sort of now, one of the words you just said was personality. Let me read the definition of that I'm coming out of a 4th edition Black's Law Dictionary, and it says, in modern civil law, the incidence of a law or statute upon persons, or that quality which makes it a personal law rather than a real law. For the personality of laws, foreign jurists generally mean all laws which concern the condition, state, and capacity of persons. And when you study this express trust under the common law, you're going to see this. Let me tell you something. That express trust under the common law book is a book that everybody should read if they want to get an understanding of everything, these things we're talking about. Because it talks about the corporations, the amalgamation of the corporations, personality, public and private, constitutional restraints. A lot of that is discussed in there, and it will give you a deeper understanding. And the more you study trust, the more you're going to see what's going on in the courtroom, too. You're going to see that it's a trust situation that's going on in the courtroom. You're going to see it. You're going to see how they're hiding things. That's another thing that they do that I guess I could say that they're at fault, because the number one fraud I think they're perpetrating on everybody is they do not reveal under what jurisdiction the court is operating under. They don't announce the type of action that's being conducted in the court, and that's what the Sixth Amendment was supposed to protect. We were supposed to know the nature and cause of the action, and they're not doing that. They're not letting us know the nature and cause of the action. And that in itself is some fraud right there, because it's not, it's not really. I mean, if you don't know the nature and cause of the action, then how are you supposed to go in and defend yourself? Yeah, So that's a thing. That is one thing I think that is wrong with what they're doing. Another thing, I'd like to give an announcement out there. There is a document on the internet that everybody should get. It is called the Pure Contract Trust User Manual. It was written first in 1994. I would strongly suggest people get that document and read it. It's called the Pure Contract Trust User's Manual. And then there's also a document called Common Law Business Trust Organization, or the Pure Trust, and that's a good primer. That's a primer. That's a good primer for you. But you should get the Pure Contract Users Manual. Let me download these right now, put them in my Dropbox, because I'm sitting here Googling these things right now. I like to give the free documents out to everybody so they'll know, where did you get that document at? Everything that I give to y'all, you can get on the internet and download it. It's right there on the internet. You ain't got to see. What's that?
It's called The Law of Private Right by George H. Smith. Pull this a PDF file.
The Law of Private Rights? Oh,
yeah.
That sounds like an interesting title. It's a very interesting title.
Goes to the definition of law, goes to classification of rights, actions, natural rights, private law, goes into modern trust. All these books are related. This deals with per individual.
Wow.
Jurisdiction. And I'm sure everybody has that Gilbert Law Summaries.
Oh yes, I got that in the that's in the Dropbox. It's in the Dropbox. I got that in the Gilbert Law Summaries on Trust. That is in the Dropbox for those who want it.
If there's something in there on page 11 about trust when you deal with public and private, there's a difference. And they lay it out in what they call other relationships. See, various fiduciary relationships at times appear similar to trust. Guardianships, receiverships, possessions of executors or administrators of estates, even corporate dictatorships, partnerships, limited liability corporations. Each of these differ from a trust. They sound like trust, but they're not trust. The moment a person mentions a private trust in a public venue, it then becomes public. So if you're in a courtroom, if an individual is in a courtroom and they have not established that this is a private jurisdiction, or they have moved into an equitable jurisdiction, guess what you're dealing in? Public trust, commerce, commercialism, totally different from the private side.
I like what you're saying right there, and that's what I tell people all the time. I gave them the definition of a public figure. When you voluntarily participate in a public controversy, you're looked at as a public figure. And this is why you can go look that word up, public figure. It will tell you that. So if you're a private individual, you should probably invoke it in some type of private proceeding before you go in and start talking about these things. But really, you don't even need to be talking. If you're a private individual, you don't even have any business talking in court. This is why they try to give people public defenders, and then when you turn around and want to accept the public defender, they want to give you a mental evaluation, because here you are claiming private rights in a public venue, all right, saying I'm a Moor, I follow this treaty, that's not my name, all these different things you in court saying. And you you don't even realize that what you're sitting here claiming is that you're a private individual. And this is why I don't like these are a couple of things I don't like about the Moorish movement is they don't explain this. They can your Moorish rights. Well, your treaties and everything, that involves the private. Okay, because what you're saying is, as a private, you have a right to live your life however you want. And the public is going to be regulated. So if you're going to know about treaties, you have to know the difference between public and private. If you do not know the difference, I don't care what you know. If you encroach upon the public side, you're going to lose, because that's their territory. You cannot win in their territory. You got to stay in your own territory.
That's right.
So if you come over into the public, I don't care what your status is, they're going to yoke you up. And they can trick you by getting you to talk a certain way. That's why they said, and they tell you all the time, you have the right to remain silent. Anything you say can and will be used against you. So when you come in and they want to give you a public defender, you should accept that because he is a public servant and he can speak in the public. And that's why they sit down by the table and tell you don't speak. Don't talk. You don't need to talk. And all this is fully explained in creditors in their bonds, that you don't need to speak under any circumstances unless you appear as a third-party intervener, and that's in the Rule 24. You are a stranger. Look up the definition of the word stranger in a law dictionary. A stranger is a person there to pay a debt for another party. There's also another term called acceptance or honor. These are legal terms that I'm giving you. All right? Study these legal terms and understand what and how you are making an appearance in these venues. You're not even really supposed to be talking. Only under the most severe circumstances can you talk, and that's when they don't give you any choice. But then you need to let it known who you are. You're hearing a third party. You're a third-party intervener. Look that word up, third-party intervener. You're a third-party intervener making a special appearance as an authorized representative for the defendant, and you're accepting the charges for value consideration in exchange for full set-off of the public charges against the defendant. You're not there to dispute anything. Why are you going to dispute fictitious, colorable charges? They're fictitious. That's called a traverse. Now you're breathing life into a fiction, and now you're giving substance to something that can now be brought before a jury to determine the facts at issue. That's what juries are for. Juries and bench trials are for fact-finding. If there's no material issue of fact in the case, then there's no need to go to a bench trial or a jury trial. So you don't want to argue. That kills the jury trial and the bench trials because there's no argument. And they're going to do everything in their power to get you to argue, and that is what they warn you about also in creditors and their bonds, how to avoid that pitfall. Oh, well, we just found 10 dead bodies under the house. What? I ain't had no bodies under the house. Got them. They want to invoke some type of emotional response from you to get you to reverse the charges, to start arguing. You're not there to argue. Do not argue. You want agreement. You're there for settlement and closure, not to argue. Agree with your advocate. It tells you, Matthew 5, go to Matthew 5:25, says it very clearly, agree with your adversary while you're on the way to court with him, lest he hand you over to the judge hand you over to the bailiff, and the bailiff cast you into prison. I tell you, you will not come out until you pay the very last farthing, or that means penny, until you pay the very last penny. They want every penny. Let me go into something. I told these people we're going to talk about bonds today. Can I talk about that real quick? Then I'll go into some other stuff. Let me talk about these UCC filings real quick, y'all. And I'm not going to hold a seminar online because that's what I do in private. But I am going to go into a couple of things for y'all, and I'm going to give you a guide. In my Dropbox, here's a jewel. Here's a jewel. Here is a major jewel that I'm giving to all you UCC people out there. Y'all spread this around. Put it everywhere so these guys can start charging y'all this money for this ridiculousness. There have been people who have been looking 2 years for the information that I'm about to give you. They come to my seminars and tell me all this stuff all the time. I've been looking for this a long time. There is a folder in the Dropbox. It's called How To. How To. It is under Private Side Solutions. It's called How To. In this particular folder, you will see a document called Order of Documents. In that order of documents, when you pull it up, you will see like 10 different sections. This is your entire roadmap for secured party creditor. All right, you have your Section 1 tells you how to do your UCC 11 search, how you get a copyright clearance from Westlaw Publishing, how you file your security agreement, your UCC 1 and your UCC 1 addendum, Section 2 goes into UCC Treasury filings, which are posted registry accounts. Your Form W-8, which you file with the IRS that shows that you're foreign. Your affidavit of tax-exempt foreign status. Now, you can Google this on the Internet. All these documents you can Google on the Internet. I would strongly suggest that if you Google an affidavit of tax-exempt foreign status, that you read it very carefully. It is a very, very good read. Revocation and termination of franchise. Your straw man is a franchise. When you read express trust under the common law, that is going to be made very clear that the United States can only regulate franchise, and the state governments, they only regulate franchises. That's what they grant rights and privileges to. That's what they're doing to you as a U.S. citizen. A U.S. citizen is nothing but a franchise of the federal government. That's all it is. Your whole harmless agreement that holds you as a private individual, because remember, it says that when you do a UCC contract trust, notice it's called a UCC contract trust agreement. The indenture of that agreement has to specify that you, as the trustee, will not be held personally liable, that if anybody wants to look for a remedy, they're going to have to look to the trust corpus to receive that remedy. Pay attention to that. Your next is going to be your SS4 forms. SS4 for foreign trust. You're going to get a 98 number, which is a trust number, so you can get you bank accounts and do banking. And you're going to find out how to do banking when you get the document that I just told y'all to get, which is the Pure Contract Trust instruction manual. Find it. I have it in the Dropbox under the trust folder. Tells you how to set up your bank accounts and all this type of stuff. Transfer your assets over into your bank account. Your trust agreements, all that is in this document. You're going to get a 45 number for your corporation and a 45 number for your estate. The directions on how to utilize that is in the Dropbox. If you go under the Gurus folder, I put in Patrick Devine. He did a very nice job with the SS4 forms, instructing you how to call the campus in Philadelphia and obtain a 98 number. It's in the Dropbox. Now, they changed some of the... A 98 number is a EIN number for a foreign entity. If you're going to do business as a foreign entity, you're bringing yourself without the United States. And this is for tax purposes, but you got to do everything properly. So you have to read this. Don't run out there and just start doing things. That's why I don't like to talk about this stuff, because I don't want people to get into trouble. But what you're doing is that you are private. What you're doing is you are privatizing yourself. And you're going to have to make certain decisions. If you're getting Social Security, welfare, any type of benefits from the government, you may not be able to do this process in its entirety.
Hey,
I know a lot of people out there. Go ahead.
Let me ask you a question, rather. See, I know a lot of people want to destroy that legal entity. But if you can set up something else and operate that something else, and in the meantime clean up that legal entity, why not?
Well, exactly. Well, that's what I propose too. I'd look at the legal entity as, I don't see a problem with it. It's how you just. It's like I said, and that man said it perfectly in express trust under the common law. He said in your sui juris status, you have the right to arrange your affairs the way that you want to. How you're going to conduct your business, basically how you're going to conduct your business in the public. Because that's what the straw man is for, public use. Okay, how you're going to interact in the public. All right, now. By default, they give us an individual or like a corporation soul. But the highest form of doing business in the public is through a common law trust or pure trust. This is what the Rockefellers use, the Mellons, the Rothschilds, the Warbirds, all these different individuals, the most powerful people on the planet, use trust. And this is also why Rockefeller and all these guys set up these colleges to teach these individuals, to set up schools to teach individuals how to manage a trust properly, because that is the key to everything. The manager of these particular trusts have to be knowledgeable individuals. It has to be properly managed. So this ain't something that you just going to jump into and start doing. This is a study, and you got to get the proper documentation to start studying, because you have to know what you're doing to manage a trust. You have to know what you're doing.
When you look at for the people, when you look at for the people that like the movie comparative, the Matrix, they existed in Zion, which is simply brought down to the word consciousness, because it's the light, Zion, the sun, consciousness, and it lived as a collective, simple lifestyle, as a collective. But when they went public, they were not wearing potato bag clothing. That brother had on alligator trench coats, tailor-made suits. They was doing business on the highest level. They were not dealing with street soldiers. They were dealing with bosses and CEOs. They was dealing with the nigga that built the Matrix. Okay?
They
so
sure
how do you perceive yourself as someone dealing with regular employees or someone controlling businesses? Clearly, they were trust. They didn't work for anybody, but they had everything. But you can see the restaurant owner, the guy who had the wife, and the restaurant owner and the twins, the European who had all the televisions, the one who created the Matrix and told him he was even a part of the Matrix. I made you several times before. These are supreme power beings that yield a certain amount of power that we have to go beyond our regular scope and tap into these resources. Don't think that banks are evil, because you don't know how to take $1 and multiply it into 10,000. Because of our naivety, of our lack of information, we become victims of what we don't know. And this is why your show, Yusuf, of giving information is important, because it's right information, it's applied information. It's not something that's theoretically or theorizing, philosophizing. It's something that you know about and others have applied. Like myself, I have a pure trust. And this pure trust is buying up blocks at a time. Collectively, though. Not with it's just me. It's a collective, amount of us. That's why I got to get you at the summit in January. But go ahead, brother. Continue on, please.
Right. But he's right. I actually, I just put an example of a irrevocable pure contract trust agreement into the Dropbox. I just found it on the internet. I haven't got a chance to read it, but it's 56 pages. It looks interesting. But this is where you want to be going, though. You want to be, if you're going to maintain privacy, if you're going, your common law rights have been transferred into trust law. That's where our common law rights. That's where the common law is. That's in trust. It's in trust. It's in order to protect your common law rights, you have to be operating your business out of a pure trust. And here's my thing too. And let me say this about the birth certificate real quick. And this is my opinion. I don't know this for a fact, but I've used a syllogistic, a deductive reasoning to come to this conclusion, and that is that the birth certificate is a security. It's a certificated security. That's why they call it a certificate. I think that the Vital Statistics Office that is holding the birth certificate is something like a safekeeping receipt. And they have placed it in trust, and they're trading it. We all know this. They're trading our birth certificates. You need to get that original birth certificate, and you need to put it in a trust. The reason I'm saying this, and because that's going to put it under your own control, because right now, somebody emailed me something talking about nationwide how the UCC offices are trying to prevent people from doing what they term straw man filings, because they look at it as fraud and an attempt to evade paying taxes. And which they are true, because a lot of the Moors, that's what they are trying to do. They're trying to avoid paying taxes when you don't even read these UCC security agreements, and that's not the object of the game. The object of the game is not to avoid paying anything. The object of the game is to discharge debt. That is what you are doing. That is the purpose of filing a bond with the Treasury Department. We are doing business. We are honorable individuals. We're not trying to evade or circumvent anything. You are a businessman. You are a private banker. You're in the business of issuing negotiable instruments into commerce. You are here to make the world a better place. That is supposed to be your ultimate goal. If you are a businessman, you are a businessman. You're not an absconding debtor. You're not a contemptuous person or anything like that. You're here to act honorably. I don't understand these filings when you come in here and you're trying to file a more. I'm a more, and I'm exercising my rights, and I don't have to do this and I don't have to do that. That's not the purpose. There isn't any money. Why are you arguing with these people? You're insane. That's what Edward Mandelhouse was saying. Go back and read his thing. He said the people who find out how our system operates are not going to want to leave the system because it's too advantageous to them. Okay? That's why it's not going to fall, because the only ones that's complaining is the dumb motherfuckers. They don't know how to operate in commerce. That's it. They're the only people complaining. I'm in California, and I heard a brother say this. I was down in the gym playing basketball, and I'm down here in Hollywood where all the actors, they go play basketball and stuff. So all around them, I'm listening to them. And he said straight up, the only people complaining is broke motherfuckers. Rich people ain't complaining.
Only when you tax their money.
Only when you tax them. But let me tell you that the ones that are wealthy and understand how to protect their wealth, they're not complaining.
Mm-hmm.
They're not complaining. And you can protect your wealth. You can get mad at, who's that dude who ran for president, who they were putting on blast talking about he didn't play. He just ran against Obama this last time. What's his name? I forgot it.
The Mormon guy?
Yeah. They was putting him on blast talking about, he don't pay taxes. And he's looking at everybody like, y'all dumb motherfucker. I ain't doing nothing wrong.
He also said corporations are people.
Oh, people. He did, and everybody got mad at him for that. He told the truth. I saw that. They jumped on him about that. And he was looking like, what the hell are wrong with you people?
Better come on in.
You can get on YouTube and find that, too. You can get on YouTube and see where he called corporate. What is his name, man? That senator.
Let me find out. Hold on.
I forgot his name, but he did. He jumped on him, because he said corporations he said corporations are persons. Everybody was like, what? He started jumping on the man, and that was just an example of how extremely ignorant the general population is, because the man didn't say nothing wrong. He told y'all the truth. He told you the truth.
You're talking about Romney?
Hold on. Yeah. Mitt Romney. Is that his name?
Yeah.
Romney. Yeah, Romney. Yeah, Romney. But they jumping on Romney. They all around. He don't pay tax. Romney ain't doing nothing wrong. Romney is an attorney, and he's educated. I think he went to Harvard too. Didn't he go to Harvard? That ain't no dumb man. That man's smart. You know what he's doing? You can do the same thing. You just have to find out how to do it. He didn't do nothing wrong. Also, let me continue. We got about 4 minutes left on the stream. A lot of people on the call today. Let me bring in a couple other people. True Freeman, your mic's still open too. You can interject anytime you want, but you got 4 minutes left on the stream. So on the internet, it's going to cut off. However, we're going to continue for the last hour of the show. The call-in number is 424-222-5250. 424-222-5250. Let me bring in a couple of callers. Got some other people, they hand up. Let me take a couple of more questions before I go in a little bit deeper. 301-5883, you're on High Frequency Radio.
Yusuf, this is Barati.
Hey, what's going on?
Yeah, I just wanted to tell you it was Romney. That's
Mitt Romney. Yeah, Mitt.
Yeah.
All right. Okay, yeah, Mitt Romney.
Figured it out.
Okay. But, yeah, it was Mitt Romney. You know, you telling everybody the truth. He just told you the truth, y'all. He don't jump on the man. Just go and read about pure contract trust and find out how you can protect your assets and you can circumvent all those taxing. You know, they taxing you because they have to, because you're using a benefit and privilege from them. And that's why they're taxing you. But when you use a pure contract trusts are for responsible individuals. You don't need the government to do things for you. You're able to do it for yourself. And that's what I'm saying. We got to get back to a point where people are responsible again. Stop complaining about these governments. You're wards of the state. You want the government to do everything for you. You want health care. You don't need health care. You need to eat the right food. You don't need medication. You need to eat the right food. It's that simple. Drink more water. Eat natural food. No more disease. It's that simple. It really is. Let me pull up the next call.
Hey.
4-4. Go ahead.
I was just going to ask about getting into securitizing bonds. You know, when you start building skyscrapers based off a piece of paper. You know, getting into that.
And that's let me tell you something. And that's the game that we're discussing right now. It's like, okay, a bond is just a promise. And then in its expanded sense of the word, you get into some negotiable instrument issues. But they have to be backed by something, some type of asset. And what is the asset that is backing these treasury bonds of the United States government when they're bankrupt? The birth certificate. Y'all got 60 more seconds to call in, y'all. Number's 424-222-5250. Let me take 2 more calls. 7741, you're on High Frequency Radio. 443-7741. Yeah, I hear you. You're on the air.
Hey, Yusuf Eel, how you doing? Hey, this is my third time
good.
your show, and you keep talking about the Dropbox. But for those of us that never, had contact, would you explain your Dropbox? Also, I caught that film on YouTube about the changes on the horizon. That's pretty good. That's good knowledge. I appreciate it.
That's a very very good video. That brother did. That individual did some very, very good research on that. Changes on the horizon, y'all. It's on YouTube. You want to check it out. A Change is on the Horizon. It's about 3 hours long. Comes in 3 parts, and it discusses the Saint Germain, which was very interesting. I didn't even know about Saint Germain like that. And then in part 2 gets into some historical issues about the country, and it gets into these. It discusses all the stuff we talk on this show. And he did a very, very good job. He put that together very, very well. So yes, it's definitely something I would recommend that people look at. It's called Change is on the Horizon.
Right. And, the Dropbox information. And also, man, I'd be glad when I see it takes effect because they're killing us out here. I mean, you got to learn. However, I don't know what to say about that whole scenario there. I don't know why, if the law is passed, they won't initiate it. It's all about greed. And it is what it is.
Okay, to get access to the Dropbox, you're going to have to call in the number. Email me. You can email me now. My email address is highfrequencyblogtalk@gmail.com. highfrequencyblogtalk@gmail.com. What I'm discussing right now is I'm discussing a piece of paper that basically shows you how, and I'm going to do, because I was thinking about actually holding a seminar online, but I'm not going to do that publicly. I just can't do that in the public. It's just too much sensitive information for me to just be broadcasting like this. But I will go as far as to give you the order of documents. This is your road map for the secured party creditor procedure. In Section 3, you will also see it has the 8832 IRS form for assigning your Social Security number, your 98 series into the foreign trust, your estate and your corporation, your mailing of the birth certificate. And let me get back on the birth certificate real quick and address this UCC1 thing, what they're doing with these straw man filings. I think
that you need to do. Everybody should do an administrative process against vital statistics using the Freedom of Information Act and demand that they turn over your original birth certificate. What you're getting when you go to the vital statistics is you're getting a certified copy of the birth certificate. In the back, they got the original. It is my understanding when you get this birth certificate, you're going to see it's been endorsed, probably from different countries from all over the world. You should demand that they turn that property over to you, but you don't need to hold it. You need to put it in trust and then put it back into commerce and make the Treasury Department a beneficiary of that particular birth certificate. Now, I'm not really giving the exact procedure to do this right now, but I do feel like that birth certificate is a very, very, it is an asset, a very, 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 very valuable asset. And that, because I already confronted the vital statistics in Texas, and we went at it, and they didn't want to give it to me. They told me they didn't have to give it to me. They wouldn't give me no laws or nothing like that. So I'm in the process of doing an administrative process against them. Now, when you conduct this administrative process against them for this birth certificate, now you can put them on the UCC1 as the debtor. Since they don't want you to put your straw man as the debtor, and they're going to call this a straw man filing, and it's a fraudulent filing because you're trying to avoid taxes or something like that, they put vital statistics on there. Okay? And then put an affidavit supporting it of why you have a claim against vital statistics for your birth certificate. Because these UCC1s need to be supported by an affidavit. You can't put no lien on anybody without a commercial affidavit. That's another reason why people get these charges and everything for fraud, for fraudulently filing liens and everything, because you don't have an affidavit. You didn't even complete the administrative process. You just got pissed off at a judge or some public officer who is exercising his delegated authority, and then you're filing a lien against him in his public capacity. You are doing fraud. You don't know what you're doing. You just pissed off filing some shit. And they do need to come fuck you up because you don't need to be doing stuff that you don't understand what you're doing. You don't. So the UCC is creative. Remember that. It is creative. There are no hard and fast rules to it. It is open for creativity. That's why no one can come and say with certainty on this phone call that my way is the way of doing things. You need to learn what the principles are that are involved, and as long as you don't violate any of the principles involved, you should be okay. Methods are many, principles are few. Remember that. There are many different methods. There's only a couple of principles. Master principles first, and then do your method, your methodology. Master your principles first. Section 4 talks about the mailing of your birth certificate, and then Section 5 is your Treasury packet, what you're going to send to the Treasury Department. Your 1040-ES, your 1040-V, your certified copy of your UCC1. Notice it's a certified copy. Notice the gentleman came on the show and said a lot of people put their copies of their UCC1s in their court cases and they're not certified. You got to put a certified copy of your UCC1 showing that you have a priority claim. Now, this is the reason also, like when you look in Section 1, you do the first thing on your UCC1 is a UCC11, which is a search. And you have to get a certified copy of the results of that search. It's like doing a title search. It's the same thing. It's exactly the same. When you buy a house, you do a title search to make sure there aren't any other claims that pre-exist against that particular piece of real estate. Because if you buy the house and there are already claims present or liens present, your lien is going to be junior to their lien. Their lien is going to be senior to yours. So if a foreclosure occurs or you want to sell your house or something like that, that lien has to be satisfied before you can have the property free and clear. This is the reason why you have a title search and you have title insurance. Well, there's no difference when you're talking about your property, which is the subject of a trust corpus. You want to make sure there are no pre-existing claims lodged against that, and that is the purpose of the commercial registry, is to give notice It doesn't constitute a lien in itself. It is just a form that they have created so we can notify everybody what's going on. So you do a UCC search on your name first, your all capital letters name, and they're going to come back with a result and say either yes, you have some claims out there, or no, you don't. If you don't have any claims, now you get a certified copy of that. Now you have prima facie evidence that you have a priority claim. Now when you go in a criminal case, you can file your UCC-1 saying I have a priority claim against my estate, a pre-existing claim. And if you don't believe that they're filing liens against you, and I've seen this in other states. I always use Georgia as an example, but you will see this in statutory codes in other states. In Georgia, y'all can pull this up on the internet. It's OCGA 1711-1. It's the cost of an action on a criminal case. They put a lien against your property when they find you guilty. Now, what property are they talking about? If I just got arrested for stealing a car, and then you find me guilty and you put a lien against me, what are you talking about? That right there should be evidence that it is a civil action and this is admiralty and it's debtor and creditor. That more than anything. So all this stuff these attorneys talking about, which are talking about this UCC stuff and all this stuff right here, I'm like, look, man, 27 CFR 72.11 says all crimes are commercials. If this is a commercial crime, shouldn't we be using the uniform commercial code? Don't let them give y'all this foolishness. It's utter buffoonery that they're out there doing. It's predicated on the fact that they really believe that the majority of the population is stupid. And in more cases than not, they're absolutely correct. But let's keep going. Let's keep going. Now, I hope I made some things clear with that, the UCC filing. Let me pull up another caller real quick before I continue. I have some questions. 302-4248 on High Frequency Radio. (302-4248). Okay, hold on, y'all. Let me pull y'all back in. Give me just a second. While I'm doing that, let me keep talking about this these filings. I'm just throwing out some ideas out there for people to take into consideration. Another thing, once you file this UCC-1, you're going to have to start thinking about getting a CUSIP number for your bonds. Unless you're going to register it as a 144A, which is basically private. It's a non-registered security, because this is a security that you're giving to the Treasury Department. If you start reading about Pure Trust can issue bonds, negotiable instruments, certificates, and all these different things. There is no money on the public side. All the money is coming from the private side, and you are the money. Don't let these people fool you, tell you anything different. There is no money on the public side. All the value for anything comes from the private, because the private is because the only thing value can only exist in the real world. The public is fictitious. It's the land of fiction. There's nothing possibly substantive could originate there. Nothing. Are my co-hosts still on the line?
Who's your co-host?
Say what?
Who's your co-host?
Oh yeah, well you are today.
Well, listen,
it's so quiet.
I can't get in the damn Dropbox, man. You said I need more memory.
All right, well, okay, hold on. I'm trying to sign back in. My computer. You know how these computers are. They I'm gonna sign out and I'm gonna sign back in so I can answer some of these emails and put people in. Did I send you an invite to Dropbox?
Yet, I go in there saying that I'm going to run out of memory, but I have a gig on my laptop. So
now what they do is they give you like 2 gigs. If it say that, I tell you what, I'm going to just send me an email and I'll email you the documents for all those who can't get in. Because I don't know why they started doing that. At first, everybody was able to get. What Dropbox is trying to do is they try to make people pay. Because my Dropbox is like 60 gigs.
They're trying to get $100 out of me.
Yeah, so they're trying to get some money out of you. So when people try to connect with my Dropbox, they only give you like 2 gigs free or something like that. And I got like 30, 40 gigs of information in my Dropbox, and, you ain't going to be able to, I guess, get all in your little 2 gigs or whatever. So what it is I'll forward people information that they need or whatever if you've already got it. Some people don't have the problem, though. Some people get in Dropbox, they don't have a problem. They call me up, hey, I don't have any problem. And then some people, I guess that may be for the people who already have a Dropbox. Maybe what you want to do is get a new email and do an invite from a different email address and see if it works like that. That works for people sometimes too.
All right.
Just do an email from another email address. But there's a folder. Right? Yeah, the folder in there is called How To, and it's an order of documents. That is a very, very. I'm giving this on the air because a lot of y'all. I'm gonna do some seminars on it still because a lot of y'all ain't gonna understand everything that's on that document. But yet, it's still just having that is very important for you to have because now it can direct you on how to do your secure party creditor process properly, and you don't have to listen to all this mythological talk out there, these individuals who do not know what the hell they are doing. They don't know what they're doing. They don't know what they're doing. Especially if they come in to file a UCC-1 and they didn't tell you to do an 11 first, they don't know what they're doing. They don't understand the purpose of the UCC-1. You have to have evidence that there's no existing claim already lodged against whatever property that you are filing a claim. And that's what Article 9 of the UCC is for, to establish priority of the claims. And people don't read that or study that because they don't study the UCC. They don't read it. So they don't know to do a UCC 11 first and all these different. They don't even know the purpose of a UCC 11. They just say, just file a 1. Do the 1. And then, do a 3. Do an addendum. And then, do some assignments. Every time, you discharge your debt, do an assignment. They're giving you the partial truth. They're not giving you the whole truth because these are individuals that are learning information from other half-informed individuals, and none of these individuals in the process are picking up books like a Gilbert Law Summaries on Article 9 of the UCC, which is an excellent book. That's what I read. Very, very good book. One of the books I read, shall I say. I love the Gilbert Law Summaries on a lot of different things. But that's something that you should read. Douglas, what is his name? Douglas, I gave him on another show. He's in Ohio, and he's a brother, too. He is one of the foremost authorities in the nation on the UCC, and he's a brother. He's a professor at Ohio State. His name is, I forgot his name. I'll pull it up. I have to remember, and I'll say it on another show. But he's up in Ohio State. You can Google him. Just put Ohio State professor in, the UCC expert, and I'm sure his name was going to pop up. His name starts with a D. But this particular individual, he talks about the UCC. And he talks about these mortgages on these foreclosures. He's going in real hard against the banks right now, too. And he's a brother. Expert on the UCC. Check out his information. He has books on the UCC that talks about this stuff.
Yeah, I was thinking, when you was talking about the bonds, you got to have that collateral. How the United States do it. For example, how Donald Trump, people look at how a lot of these guys became millionaires. They became millionaires through real estate. Real estate is part of your asset, right? The collateral is used as collateral for the bond or a bond to build tens of millions of dollars worth of real estate in one particular area. But let's say, for example, you don't have millions of dollars of assets. I'm going to just throw something out there. Let's say I have a foreign entity that resides in a land that has huge amounts of gold and diamond deposits, and it's inside of a trust, and it's doing business on paper on this continent. And now I want to use that as collateral for a bond to go and purchase more real estate. See, the trust, you can do that. This is all theory till I apply it. But I know some people, you can get lines of credit based off of what's in your trust on that document. They never have to see it, but it's stated.
You're absolutely correct. You're 100% correct. There is a book called The Hold a Pale Horse by William Cooper. I know you.
That's right.
You're aware. I know you know.
You know
that. But there is a article in there. It's called The Story of Jonathan May. It's about land banks. He instituted the first land bank, and he was a foreigner, came over to the United States, and what he did was he did a geological survey of particular property and was able to demonstrate that this particular property had large amounts of gold and silver on it, and he hadn't mined it yet, but he was able to use that particular property to form a land bank, and he was going to issue money that was gold backed. And the government arrested him. Matter of fact, he tried to contact Joe Biden and all of them. Go read the story. Joe Biden, now the Vice President of the United States. But you got to read his story, and he talked about how he was trying to help the country, and he brought this idea to the United States government, and they arrested him, gave him 10 years in prison, and then took his idea and started using it for themselves.
How about that?
Now, if you want to understand this stuff, what you just start explaining, that is a very, very good story to read because he drop a lot of information in that particular story. And I know I got a lot of people in here who are doing mining operations in Africa, or they're looking for funding to do mining operations and so forth. Read that story about Jonathan May. Story of Jonathan May.
That book, period, is just awesome.
Yeah, it is. It is.
I don't want to get off task. That's easy to get off task. But I want to add to the trust aspect and proving the trust. You can use your birth certificate as a res because it fit what a res is. Now, you don't bring your trust out until, like, for example, if you're in a courtroom, until it's proven that you are in a private situation. You have two jurisdictions. This is when a judge becomes a chancery. Now you're in an equitable jurisdiction where you can talk about equity, boom, boom, boom. But I just want people to understand that equity and commerce, UCC, are two different things. They can't commingle. They can't be together. There's two different. There's commerce, and then one is the equitable aspect of it. There's a lawsuit that a guy was having a house built. Before one nail was dug into the ground, of cement poured, my man put all the equity out the house. Got that money. Because of maxims of equity. When you say you do equity, it looks as if it has already been done. Versus the statutes and codes of the legal system. So my man won a lawsuit because he knew how to enforce it. And this is one of the keys of when you want to tap into a certain amount of funding, knowing how to do that.
And that's what I'm talking about. Basically, I guess I was alluding to or getting to is using the birth certificate as the raise for the trust to serve as an asset to back, instruments that you're going to be issuing in commerce for discharge of a debt. But I'm really thinking, though, we need to be trying to get the original birth certificate, not these certified copies of it, because they are the custodian of that document. That man down in Vital Statistics told me that. And when you understand how everything operates, what safekeeping receipts are and so forth, safekeeping receipt evidence is that somebody is in custody of assets that have been assessed and have been given a certain value.
And it's the same thing with this particular birth certificate. They are the custodian of that particular document, and that document is a negotiable. It is a bond. Right there at the bottom of it, you have American Bank Note Company, Midwest Bank Note Company, Pacific Bank Note Company, and they have some of those things under it. And it's letting you know that this is some sort of bond and that it has a value associated with it, but they are just issuing you a certificate that evidences. They're not giving you the live birth record. They're giving you a certificate, which is, of this particular, represents an interest in that particular document. I think we need to get those original birth certificates and put them in a private trust and start operating in commerce on our own, and make sure that the United States government has make sure they have a beneficial interest in that, because you don't want to be looked at as because a lot of this discussion could make you an enemy of the state, because the United States is bankrupt, and you always want to make sure that you do not have an adverse interest to the United States. You're not a threat to their interest.
That's right.
Don't be a threat to the United States interest. You don't want to be an enemy of the state. You don't. You don't want to get labeled. They will show you, trust me, they will show you very quickly what they will do with you if you are an enemy of the state. So you don't ever want to allow them to put you in that situation. Go ahead.
If we can't get the original document, now I've been doing my study, and I don't want to call this guy name out, but he's got some excellent information. I don't want to direct people to that till I figure out. But the withdrawal and redeposit move is a strong move on that BC, because then it puts you as the original holder. But you have to have forms of record and proof. And this is where non-filing, what they call a non-filing of a UCC. You understand? So it's not, they have to do a search for it, but it don't, you have to look at UCC 1 non-filing. And a UCC 3, you move them, and UCC 3 tells us that they exist. And this is what's called a special deposit, which is a withdrawal and redeposit over the BC, which will put you as not a holder in due course, but the highest capture of the birth certificate. And then
when there would be a holder in due course, that would be the highest level, holder in due course. Because they're just, really, to me, in my opinion. Go ahead.
Go ahead.
No,
I was just going to say that it's certain terminologies that mix them up. There's another term versus holding due course versus in the trust aspect, which I'm looking. I'm looking for while we're building, but.
Well, in my opinion, you're already the holder in due course. They are just the holder of that particular document. You are the holder in due course, and you have to make a claim to it. And then there are certain claims and defenses. It's called real defenses that can be exercised against a holder in due course. There's only 10 of them. But, I mean, that does have to be established. I just think, and I like what you're saying about if you're not able to get it. My understanding is that you can get it. I talked to the people there at Vital Statistics. He told me you can get it. But he told me, he said, look, we're the custodian of that document. If we give it to you, you lose it, that's it. And that's all he told me. That's how he said it. But then when I talked to him, he said, I can't give it to you. The manager has to give it to you. Then when the manager came over, I started talking to him. He was like, he got pissed off. He's like, we don't have to give you that. I said, well, okay, show me the law that says you don't have to give me that. Well, I don't have it right now, but we don't have to give it. State statute says we don't have to give it to you.
I think a claim. I think official claim. Because that's what it is. Versus, hey man, it's me, that's mine. Let me get that. I think if we do, remember it's a paper game. We get the official procedure to putting us in the highest position. That's a claim. Let me get that. Even if they may not understand it. Mm-hmm.
Well, what I've seen in commerce, everything in the public operates off of presumption, assumption, and color of law. And from what I read in the law books, you have to make a claim. They're operating from a presumption, and you have to kill that presumption. And you do that presumption by giving them notice. You notify these people that, look, okay, I done found out, and you write it in your own words. That's why I say, don't follow other people's processes.
Yep.
Do not follow other people's processes. Sit back and read the law books, and things start to come to you. You say, you know what, I'm going to like these people and tell them, look, I know y'all got my damn birth certificate. Here's the Freedom of Information Act under the United States. That's USC Title V. That's where you find the Freedom of Information Act. I want you to give me I want y'all to turn over my birth certificate, and if you don't turn it over, I want all the information that has to do with my birth certificate. I want it now. Give me my original birth certificate. I don't want y'all to be custodians of that document. It's my understanding that you're engaged in fraud or in some shape, form, or fashion. This affects my status here in this country and puts me in a subject status, making me subject to statutory codes, rules, and regulations, and does not allow me to exercise my private rights granted to me by the infallible creator of the boundless universe, protected from encroachment by the Constitution for the United States of America. I need to get this information right now. Something like that, you know what I'm saying? And do an administrative process, send it certified mail with an affidavit of mailing from a notary, give them 10 days to respond, and when they don't respond, send them another notice saying, look, I asked you about my birth certificate now. Obviously you thought I was playing the first time I contacted you. What's up? I'm giving you another opportunity to cure your default. After that, I'm going to file a certificate of non-response is going to be issued by a notary, and I'm going to file a claim. I'm going to put it on a UCC-1, and I'm going to file a claim against my birth certificate and vital statistics. Because you cannot charge a person with fraud when you're giving them notice of what you're about to do. You see what I'm saying? They can't say it's fraudulent. You gave them notice. It's like, okay, here's the documentation. Here's the letter. Then you file all that. When you file that UCC-1, you put them exhibits. You file that in the commercial chamber with it. Here's my first letter I sent to these people. My second letter. Here's an affidavit, a commercial affidavit that I'm filing along with it. And here's a certificate of non-response. Right now I'm filing a claim against vital statistics. And I'm going to use this as the basis, and then now I'm going to send this off to the Treasury Department. Because your birth certificate goes to vital statistics, to the Department of Commerce. Pay attention, y'all. I'm from Dallas, Texas. We used to have to go to the Department of Commerce to find vital statistics. They moved it now. But when I was growing up, whenever I wanted a copy of my birth certificate, I had to go down to the Department of Commerce. I didn't know why. My mom used to tell me, go down to the Commerce building, go get it. Vital statistics was in the Department of Commerce. And from the Commerce, it goes to the Treasury Department. They issue bonds off of it and sell it to the Federal Reserve, or they're purchased by the Federal Reserve. And then they issue these promissory notes. And if you look on these promissory notes and pay attention to the back of your Social Security card, the numbers on the promissory notes of y'all money look strangely similar to the number on the back of your Social Security card. Pay attention. They have a holding company in New York on 55 Water Street, Depository Trust Corporation. A subsidiary of that is the Depository Trust Clearing Corporation, and they have a holding company called Seed Corporation, C-E-D-E. When you look up the word seed, it means to relinquish. So if they are in possession of your birth certificate, then you are relinquishing something, like to concede something. I don't think any of this that I'm saying to y'all, is a coincidence. I could be wrong. But the thing about being wrong is this: I don't think nobody gonna got the nerve, like one of these public servants, call in and tell me I'm wrong, because then they got to tell us what's right. But I really think that there is a remedy. Take this order of documents and use it as a roadmap and study it very, very clearly. Once you have it, there's not going to be anybody in the nation that can come to you and tell you, oh, I got this, or I got this information. Nah, I ain't got nothing. I already got that. It is time for us to take this to another level. Oh, my God, I got a lot of people with their hands up. Why all y'all got y'all hands up like this?
Hey, while you do that, let me check this out. If we look at the birth certificate as a title, when you know about merging titles, when you do a survey, you are creating the title. Birth certificates can be resurveyed and changed, which puts it in a special nature, which goes back into the redeposit aspect, which ties into one of the formations of a trust, that thing inside of the trust, leaps and bounds, that whole piece. The birth certificate fit that whole piece inside the birth certificate. Titles are certificates and securities of derivatives off of equitable assets. Your signature is the equitable asset. So merge of the security agreement back into the estate and terminate the transfer lien of the beneficiary. Right back into the conveyed party, something like that.
Good information. I like that. Your signature is an equitable asset. Let me take some calls. We got a lot of people with their hands up. Let's run through them real quick. 925-9200 on High Frequency Radio. 925-9200. You're on the air. Hit your mute button. You may have accidentally muted your phone. Okay. Wait a minute, hold on. Let me see. 312-7424. You're on High Frequency Radio.
I don't know where it's at. Okay.
312-7424.
How you doing, lady?
Hey, peace.
What program were
Summer Nutrition Area.
Okay, just a moment.
That was 312. Hello? Uh-oh, these people ain't listening. All right, let me do this one. 317-1096.
Yeah, this True Free, man. I got smart this time. They cut me out. They cut me off on my cell phone, so I used the house number. I ended up getting the house line just for that purpose, basically. So I called in on the other line because I knew what I was going to do. So I'm back in. Y'all was talking about the birth certificate. Have you ever thought about, since the certificate of live birth is what they did, they took and created a security by way of the birth certificate, and they did it through fraud, which even if anybody looks at their certificate of live birth, you see that your mother is listed as an informant. That's old news, but I think a lot of people are missing that. Look up what an informant is.
Right.
Your mother basically turned you over to them. So for I just want your see what you think about this, because I've been thinking about this for a few years. Just never did really delve back into it. But since the certificate of the birth certificate was created by the certificate of live birth through our mother being a snitch, basically not knowing. For those whose mothers are alive, what do you think? Do you have any? What do you think about the mothers that are still alive rescinding their signature on the certificate of live birth?
That's an excellent idea, and I get in an affidavit from them basically spelling out how they were not fully informed of what they were doing. See, that's an example right there of the creativity of all this. Once you learn the principles, you know that you can rescind your signature. You know this is fraud. Okay, well, now I would do that, and how I would do that against the hospital, if the hospital is still around, and if that, especially if that doctor, and also against vital statistics, because they are the custodian of that particular document, and let them know that, hey, I want to rescind the signature. Now, I don't know, though, if rescinding the signature is the best idea, because I want my birth certificate, I want to operate in commerce.
Now, that's why I wanted your opinion, because I was thinking the same thing. I'm like, okay, would that basically cancel or straw man in our ability to operate in commerce? Now, that's something I'm going to have to really dig back deep into. But I think there's something to that, and I think we need to be really looking into that, because it may be
there's so many millions of dollars on the line. Let me ask you a question. If you had custody of billions of dollars and somebody wanted to come through and just rescind a signature and take away all that money, would you make it easy for them?
Oh, hell, absolutely not.
Yeah, so I don't think
I don't think it's going to be that easy. But go ahead.
Okay, let me throw something else at you to go along with that, because I got a lot flipping around in this big head of mine. It ain't that big. It's just as full of information. But, okay, now let's look at it this way. Okay, since exactly what I just said about, our mother basically through the certificate of live birth has basically given us over as a ward to the state, basically, etc., through the certificate of live birth. How about for the mothers that are still alive? And I'm throwing some stuff out there for you people out there who be on your shit. So, we can come together and figure this shit out. But how about if for those whose mothers are still alive, doing a Form 56 and a fiduciary appointment to the hospital as well as the Department of Vital Statistics, and doing a Form 56, which is an appointment of fiduciary trustee. But in order to do that, I mean, if what people don't know about the Form 56 is when you do the Form 56, you're appointing somebody as a fiduciary trustee over something. But what people are failing to do is give them instructions. So if somebody appoints you into a fiduciary or trustee position, but they do not give you instructions, you have no authority to do anything with that trust. You're just sitting as a fiduciary or trustee over the trust, but you have not been given any specific instructions. I think that's a big mistake people are making. So how about the mothers? What do you think about the mothers that are still alive for, some of us or whatever, doing a Form 56 and then appointing them, doing a fiduciary appointment, which is going to lay out the instructions that they are giving them, which is to take care of the public debt of the trust. I mean, public debt of the straw man, so to speak.
Yeah, go ahead, Dialogue, then I'll answer this question. Go ahead.
Let me give you a different perspective. See, we looking at that piece of paper. That piece of paper is just something that says something else exists, which is what people are trying to get their hands on because they say there's a bunch of money behind it. But I can tell you this, for a cold fact, you could do something totally else. Get $500, get close to $1 million. It don't have nothing to do with a birth certificate. But it has a lot to do with trust. Now, when you talk about mothers doing these things for their birth certificate, let's say, for example, she is the one that informed them of the information. The country went broke, so in order to keep the country afloat, they had to create some other type of collateral, documents, and sweat equity. Whether people deem it as evil or not, if your corporation was going under, what would you do in that situation? Now, they said that you were supposed to come and claim it, just the same as the people are supposed to come and claim their land. That's why they got the Department of Land Bureau, where you can get your load of your title, and you're out of their jurisdiction. If you don't know shit, you think they're the bad guy. It's right there for you. Remember, they work for you. They set it up for their children, but their children are no longer existing, so now you're what's left, the immigrants and the Aboriginal people, what's left on this globe. So now you're getting into this information, but you have to have different perspectives of it, not just the good and the bad, but maybe business-wise, because it is originally 13 corporations. So if your mother did inform them to put this information on this document so that they could continue to have a float in the global industry, and that they did go and put it in the Department of Commerce, the jurisdiction was then transferred over to the legal entity, not that flesh and blood. But what you do is this. You can create your document that says, this person on that document, you don't have jurisdiction over. See, we didn't create the legal entity on the paper. They did, so you can't destroy it. You can get to a point of controlling it and navigating with it because it's shadowed with it. So if there's ever a legal entity, if there's a legal issue with that, you pull out your document that says that you put it on the record. And this is why trust is important, because you, your name, anything that you own goes into private trust. And when they breach it, you pull it out and prove it. You can't take this child. This child doesn't belong to you. It's, is that. But, and when you get into contracting, understand this. If I sign a contract with high frequency radio, contracts are negotiable. I have to utilize that same form or a form that's similar to it to get out of it. I can't just go. Now, this is the argument a lot of people had. I've had this argument for 15 years with a lot of I know y'all said something about the signature, but I've always debated saying that, well, I didn't verbally go into saying my signature. I went in and signed the driver's license document myself. So I would use basically the driver's license form, a skeleton form, and this is in the law. Transfer it out and say, listen, I'm getting up out of this thing, boom, 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 using that form, not something that I just created. And this is why people get upset when it don't work. But when you use their form in a skeleton form, like you use a bin, not their W-4, but in lieu of a W-4 form. So if you signed a birth certificate, say, for example, as a contract, then you would use in lieu of a birth certificate to get out of it. Or they would already have it for you. You always have two choices when they create these legal laws. Because the legal aspect is just the legal, it's not the substantive part. That's it, brother.
I agree. It's my take on it is, and I understand what you're saying as far as they got a thing called necessaries, though. Look that word up in a law dictionary. It's called necessaries. This is what the birth certificate constitutes. The reason they need a birth certificate for you is because it's being viewed that you're going to come in and be a citizen of society, and they got to print enough money to accommodate the number of people who are coming into society. All right. Every time a baby is born, they print money to accommodate that baby because there has to be enough money in circulation for that particular child. And they look at it, well, okay, you're going to be worth, an average person. That's why they have a minimum wage also, because everybody has a minimum amount that they're worth. Notice that they don't have a maximum wage. They only have a minimum wage. So it's the minimum amount that everybody on the planet is worth, so they can have a table and they can estimate if you just work a minimum wage your entire life, you're going to be worth about $600,000, $650,000, or $1 million in your lifetime. That's based off of a minimum wage. All right? So that money comes in circulation, and that's the necessaries for you to survive off of in society. You're going to need that. That's what it's for. What they're doing, in my opinion, is not bad. It's not evil. It is just that they have a system that is set up to accommodate people who are irresponsible, who cannot take care of themselves. That's what the government does. That's why you call a ward of the state. So if you don't demonstrate at some point in your life that you're capable of taking care of yourself, you see these people, and they show it every day on television, all these people hollering about health care. People who holler about health care, that is, they say, look, see what we're saying? These people they're heathens. They eat the wrong food. They don't take care of themselves. They don't exercise, and they need us. And then you come and call the government to come in and cure something that you are doing to yourself. You're doing it to yourself. And then you want to turn around and call them evil. It makes no sense. So
the government itself is not evil. It's these handful, and I don't literally mean a handful because it's way more than literally a handful, but it's just the corrupt ones in a position of power that then basically took advantage of our ignorance. So really, the government, they always provide us a remedy. I knew that. Basically what the caller, like he was just saying about, the forms and all this and that. I mean, everything they're doing to us, they provide us a remedy, but, we in turn basically look over the remedy or we expect somebody else to find it for us. I mean, everything they're doing to us, we have it remedy. We have a remedy in the private. We just have to figure it out. It's just like learning the rules of a game. I always say that it's a total game that they're playing. And we're getting bent over because we don't know the rules to the game. You go to the casino and you start putting money in a slot machine and you don't read the payouts and you don't read all that, you know what I mean? You're going to get bent over. That might not be a good payout game. You see what I'm saying? You have to read the rules of the game prior to playing the game. Now, they done brought us into their game, but at the same time, ignorance of the law is no excuse. That's why it's our duty and the responsibility to know the law. and that's how we gonna figure out our remedy. It's a process of trial and error, man, and that's what like this show is bringing to the table. It's like, we got a right to come together and figure out what's best for us and our people, and it is what it is. But
we do.
We all got to put something in this, and we definitely got to know the rules of the game. You're not gonna go bet $1 million on a chess game and you ain't learned the rules. You're gonna learn the game first, and then you're gonna run in there and you're gonna tear their ass up. So all of you who don't have court cases and issues and everything, now's the time for y'all to get to know what the hell is going on and how to defend it. And you can stop them from, day one.
Yeah.
Go ahead.
What we also do is we spend too much time watching television. I think television is a big detriment. Let me bring in another caller real quick, 786-7796. I know you've been waiting. High Frequency Radio, 786-7796. Man, let me hold on real quick. I'm gonna get you in. Let me try this real quick. Let me see something. Ooh. Y'all go ahead. Y'all keep talking. I'm over here having some technical difficulties. Let me straighten them out real quick.
I want to know if we're going to get you out here to this summit, man, in January.
The last one I couldn't make it. It was kind of short notice, but I definitely want to come back out there to Florida and check you out. I do these road trips every now and then. Like sometimes, there'll be a couple of months I'm gone 3-4 times a month. I'm going to different states, and then I take a couple of months and I just sit back and and just chill and whatever. And then I hit the road again. I go back on the road, go around the country. So, I'm going to get out there. Definitely want to get out there. So you have a summit. Go ahead and make the announcement for the summit. You're having a summit in January?
I was talking about.
It's called Summit of the Moors. It's not a religious thing. It is an economic. It's for the group of us to create an economic base, securing economics. So it's basically, if you ever read Dr. Chancellor Williams' book, that's right there. Dr. Chancellor's book, Destruction of Black Civilization. If you've ever read Dr. Amos Wilson's Blueprint for Black Power, or if you've ever read Dr. Claude Anderson, Powernomics, all three of those books have a financial sector plan in them. One came out in 1987, the next one came in 2000, the next one came in 2007. They basically are showing if we want to be able to save our community, we're going to have to be able to own and control some things. Not just some things, but an entire sector. So when you go buy jewelry up in New York, who do you think controls the jewelry district in New York City? The Jews. And it's not by coincidence. It's all by design and by plan, because they work together collectively. And guess what those little small group of Jews can do? They can affect American foreign policy against their homeland. You understand? So now you're talking about yielding political power, which is what we have to do. Voting ain't gonna get shit done. Civil rights ain't gonna get nothing done. Cut the check. And let's get things done. Let's build something and let's yield the power. And so that's what it's doing. We started basically I have everything: food, clothing, and shelter. Which one do you control? We don't control any of it. So we start with the farming aspect. So we put a farm in every state. Not only does that change the paradigm of eliminating food deserts in the area, people eating healthy, we're controlling, we're educating, we're empowering. Then we look at the commercial, before we do that, we have already looked at the commercial and the residential area of where we're dropping that farm off. And that's basically going to be ground zero, where we go in and become the majority stakeholder of that area. And now we're looking at several Black Wall Streets, if you may, several Tulsa, Oklahomas. So now you're talking about a group of people, a small group of people that own 50 farms, 16 healthy grocery stores, 3 credit unions. You understand what I'm saying? And that's not been done. And on top of that, distribution, manufacturing, other than that, and then, next year we'll be getting into technology and oil. But that's what it is. And, the element of use of L will fit right along with what we're already doing at the summit.
I'd like to come to the summit and broadcast live from the summit, you know, and just be on there. I'm broadcasting live from Summit of the Moors, you know. Walk around and interview people, put them on the radio.
Yeah, because we as a people, we what they call black people. I don't refer to myself as that. I ain't going to get into it, but I'm just going for the sake of conversation. We as black people I know that's our biggest problem, man. We too jealous of each other. We do not work together. Every other, what they call race, and race is nothing but status. Look the word up. It has nothing to do with color, but what they call race, we the only one on the face of this earth that don't work with each other. We work against each other. That's just like, you know, we crying about the Trayvon Martin shooting, you know, but, you know, when it's he ain't even white anyway, but neither here nor there. But we cry when somebody else kills one of our people, but we glorify when we kill each other. You know, I mean, it's just ridiculous how our people treat each other, you know, and we got to start having some damn respect for each other, you know, and respect for each other's opinion and position. And until we do that, man, we lost, you know, we really lost at sea. You know, it's like, man, we need us as people, man, our community, we need to really start looking out for each other. And that's a big problem that we have. Everybody wants to be first to bring this out. Everybody wants to be first to have this. Everybody wants a BMW but don't want nobody else to have one. You know what I mean? It's like, okay, I want you to have what I have. You know what I mean? Anybody that know me, it's like, shit, look, I don't even care about this shit. I know it ain't no money, etc. I'm not even fighting for that. I'm right now fighting for my freedom. You know what I mean? My mother and my grandmother raised a man, and I know how to survive without any of their assistance. You know, and I'm trying to bring others on that same level. You know, it's like, you know, we just got to work together, people. I mean, we in competition with each other. What the hell for? You know what I mean?
Well, that's
go ahead.
One of the things about the summit is not just creating economic security, but what it does is, when we create these communities, for example, when we purchase these homes, these empty plots, we become the bank. So we make it affordable for the people that we know to live in that home. So we want people to own the homes that we know. So now we're changing that neighborhood with like-minded people. So now you got RBGs, Pan-Africanists, Yoruba, Moors, all living in an enclave controlled and owned by us. So we know that dollar circulate. We know each other. If your boy act bad, I'm going to whip his ass. He going to get another ass before he get home. We bringing it back.
Yep. Exactly. Let me ask you on what you just said, brother. Have you ever seen the movie Stick Up Kid?
Yeah, I've seen it.
Yeah, that's basically what you're saying, right?
Yeah, I mean, you know, but if we go back to, like, I'm 40, I'll be 42. So if we go back to when I was 10, when the people, matter of fact, let me go back further than that. Let's go back to Jim Crow days when our people was not allowed to go across the track. See, they had no choice, so that dollar had to circulate. The school teachers lived next door to us. The bankers lived down the street from us, and we all knew each other. Now, because of the 60s civil rights movement, we think that the European water and grass is greener and colder than ours. And the money now has been disseminated around the globe, and we brag about our buying and spending power. We only had that because we don't own shit. Had we owned the manufacturing companies, the retail companies, the wholesale, that would not be part of our conversation. So in doing that, I've only seen that this is one of the real solutions, and it's inheritable, which means our great grandbabies will be able to thrive in certain communities and own and control these communities and influence the other ones to get on board with this plan.
Okay. Yeah, and I highly suggest any of y'all on the call that haven't seen the movie Stick Up Kid. You know, they don't tell you everything, but that's a good movie to check out. You know, in regards to basically the Moors, shit about the land. You know how what they did was they end up coming back in, what the brother was just saying, and controlling the community. They start buying up everything in it. They start putting their people back in it, and they actually became the bank for the people. You know what I mean? They were basically trustees for the people. Man, they tell us all kind of shit. We just too dumb, you know, to really comprehend, so to speak. You know, and that's where we got to work together, people. I mean, shit, you can't get it if I ain't got it.
Don't
You know what I mean?
It only seems like sometimes when I watch these movies, I think they be in the background because I think about the directors who put the movies together and everything, and you gotta wonder what they're discussing in the background. And maybe be in the background saying, "Man, watch this, man. I'm gonna put this shit in this movie. What these dumb motherfuckers don't see what we saying, what we talking about." It's almost, it's almost like they sit in the background saying that sometimes. It's like, now my understanding is a lot of things that they put out in movies is for certain people. That's the way they communicate what they're going to do next. There's a lot of people who understand, what's about to jump off or what's about to happen. But okay, hey y'all, I got to do this though. We have reached the end of the show. It was a great show today. We're going to be continuing tomorrow with my co-host Paul David Savagel, National Agenda. I'm going to continue this show on Friday. We're going to do bonds, bills of exchange. I'm going to get into a little bit more in-depth on the International Bill of Exchange, the United Nations Conference on International Trade Law. Y'all need to Google that. And putting together these negotiable instruments and doing these UCC3 assignments on the discharge of debt. You'll have your order of documents. If you need access to the Dropbox, you need to email me at highfrequencyblogtalk@gmail.com. I'm going to put you in the Dropbox. Ain't hiding nothing from you. We're going to take it to the next level on this information, y'all. It's time. It's time. But for right now, I have to end the call. We've reached the end of another day. I will see everybody Friday, bright and early. Y'all tune in. We're going to drop some more jewels for you. And I'll see you then. Peace.
Peace.
Peace.